Welcome, everybody. Wonderful to see you here. My name is Claire Finkelstein, and I'm the faculty director of the Center for Ethics and the Rule of Law. CERL was founded in 2012 to address issues in national security at the intersection of ethics, national security, and the rule of law. CERL is a nonpartisan, interdisciplinary institute dedicated to preserving and promoting ethics and the rule of law in national security, warfare, and democratic governance. Presently affiliated with the Altenburg Public Policy Center at Penn, CERL draws from the study of law, philosophy, and ethics to answer difficult questions that arise in times of war and contemporary transnational conflicts and in democratic governance. Today's program, which is entitled Threats to the Rule of Law and National Security, will cover a number of issues in national security, but our first panel is going to begin with threats to the rule of law from the standpoint of partisan attacks on the legal profession. This is one of the core issues, as we see it, with regard to the preservation and promotion of the rule of law, the attacks on law firms, on judges, and the difficulty that that poses for democratic governance and for the practice of national security law is something that our extraordinary panelists will be exploring in the next hour, and that audience members will be able to explore during our Q&A session at the end. I'm very pleased. I'm going to move right along, though there are lots of things that I could say to introduce this subject. I'm going to leave that to our panelists. But after this panel, we're going to have a session on presidential authority, emergency powers, and military operations in a changing political landscape, and I'll be moderating that panel. Our third panel will be on national security and advanced technologies, AI, robotics, and the security of our nuclear arsenals. And then we're going to talk about countering malign foreign interference in U.S. democracy, U.S. intelligence operations past, present, and future. At the end of this mini symposium, we'll have a lovely reception right here from 6:30 to 7:30, so we hope that you'll stay for the full program and join us at the end of the day for that reception. So I'd like to turn it over now to my colleague, Professor Mitch Berman. Mitch is a professor of constitutional law and criminal law at Penn at the law school, and he'll tell you more about himself and then introduce our panelists. Thanks so much to our panelists and to all of you for coming out today.
Thank you so much, Claire. Can people hear me okay? Thank you very much, Claire, for putting on this great event and for your leadership and creation of CERL, and for inviting me to participate on this very distinguished panel on an incredibly important subject. Claire said I'd tell you more about myself. There's really not much more to say. I've been at the law school for a decade. I love teaching there. I also have an appointment at the Wharton School in Legal Studies and Business Ethics and at the Philosophy Department. But my main fields are constitutional law and theory and philosophy of law. I'm going to start by giving just a little bit of background, factual background on this panel. I suspect that probably all of you have a good sense of what's been happening recently, but just to ensure that we're all basically on the same page, I'm going to give some bare bones facts of recent developments. Then I'm going to introduce our very distinguished panelists, and then I will ask some questions for them and really turn over so we can hear from them, who are experts on this particular subject, as I am not. The panel is entitled Partisan Attacks on the Legal Profession. I might prefer to call it autocratic attacks on the legal profession. It's true that the Republican Party has signed up behind this endeavor, but we know that this is really driven by the whims and needs and wants of one person in particular, our President Donald Trump. He's mounting he and his administration are mounting a multi-pronged attack on the legal profession. And as I see it, it might be useful to identify 4 basic prongs of that attack. The first prong is an attack on courts and judges. Here, Trump has ratcheted up his rhetoric from his first term and after his first term regarding corrupt judges, bringing derision and contempt and criticism upon judges who issue rulings that he doesn't like. This is true, of course, in the case of Judge James Boasberg, who has ordered the Trump administration not to send persons to Venezuelans to El Salvador, and whose orders the Trump administration first disobeyed, and who Trump has called the judge corrupt, a corrupt judge, a crooked judge, and Republican members of Congress have already brought forth, I think, at least half a dozen bills of impeachment to impeach federal judges for doing their job. There's no realistic prospect right now of any judges being impeached, but this is just ratcheting up the criticisms of judges and courts from his first term. There have also been attacks on professional attorneys at the Department of Justice who have been demoted and fired for doing their regular jobs in enforcing the law. A large number of individual officials, former officials, current officials, and individual attorneys who have been involved in one way or another in impeachment actions against Trump or other actions against Trump have been targeted and have had their security clearances revoked. In some cases, this is more a symbolic matter for persons like Alvin Bragg or Letitia James in New York, perhaps, but for other persons, it is a matter of a direct attack on their ability to continue doing their job and to earn their livelihoods. And then last, in the fourth bucket, at least as I'm carving things, are his attacks on big law, some of the nation's biggest law firms and most powerful law firms, whom he has attacked by doing 2 main things: again, revoking security clearances for the firm and directing agencies to terminate contracts with these firms, also prohibiting federal employees in various ways from engaging with them and requiring persons who want to contract with the federal government to list their firms as firms they're associated with or that represent them, with the idea that they would not be able to get any new governmental contracts. This last action, which is unprecedented, has achieved perhaps the most recent press because of the firms that are involved and the actions that these firms, or the disparity of the actions that firms have taken in response to these executive orders. So the first target of these executive orders, Perkins Coie, challenged the executive order in court and refused to acquiesce to Trump's demands. The next firms that were targeted did not do so, most notably Paul Weiss, the New York-based firm that agreed to perform $40 million of pro bono work for Trump-approved clients and causes in order to hopefully get its security clearances back. That was followed by Skadden and Wilkie, who agreed to $100 million. Each firm agreed to perform $100 million of pro bono work for Trump-approved causes and clients in order to get back on his good graces. Perkins Coie, as I said, fought and is fighting right now, as are others of the nation's great law firms. Jenner, the Chicago-based Jenner and Block, and Wilmer Hale have both, like Perkins, fought this in court and said, we're challenging these orders and the revocation of our security clearances as illegal and unconstitutional. One of those briefs, the brief for Wilmer Hale was authored by Paul Clement, and really quite an extraordinary job of lawyering, which is one of the reasons why I would focus this more as an autocratic attack supported by elements of the Republican Party as opposed to a Republican attack on the rule of law. So vastly different responses to this action by the Trump administration. 500 law firms signed an amicus brief in support of Perkins Coie, but as has been noted by the mainstream media, big law was, for the most part, conspicuously absent from those 500 firms. Only half a dozen or maybe a few more of the nation's biggest law firms were willing to sign on to the amicus briefs. Firms like Arnold and Porter, Covington and Burling, but for the most part, most of those 500 firms are the smaller firms. These actions have attracted criticism from major figures, including Chief Justice John Roberts, who criticized the attack on judges and calls for impeachment of individual judges, also from the American Bar Association and others, although thus far I think it's unclear that these actions have had any great effect. A couple of weeks ago, President Trump directed the Attorney General, quote, to seek sanctions against attorneys and law firms who engage in frivolous, unreasonable, and vexatious litigation against the United States or in matters before executive departments and agencies. And only 2 days ago, the U.S. House of Representatives passed a bill on party lines to limit federal judges' power to oppose President Donald Trump, his policies with injunction. So the House passed a bill that would limit the federal judiciary's ability to issue injunctions in support of any rulings against the Trump administration. Nobody thinks that's going to successfully pass, or few people think it's going to pass the Senate, but these are the things that we're looking at right now. And just 2 days ago, the Trump administration issued another executive order against another big firm, Sussman Godfrey, and Sussman Godfrey has vowed to fight it in court. Okay. That, in very quick and broad strokes, are some of the factual background. We are blessed with a very distinguished panel who are going to address the issues that are raised by these actions. How far are they going to go? Are they going to be successful? Are the firms going to win in court? And what can others of us, interested citizens and lawyers alike, do to push back against these challenges? I'm now going to just give a brief bio of all our panelists, and then we'll ask questions of them. First, alphabetically, Gary Deutsch is Managing Chief Counsel for a national bank and leads the litigation group supporting the bank's consumer lending division. Prior to his current position, Gary was Assistant General Counsel and Chief Litigation Counsel for a large regional bank. Gary is a regent of the American College of Consumer Financial Services Lawyers, and he currently serves as a board member of CERL, and he's a volunteer consultant for Penn PAC. Stuart Gerson is a longtime trial and appellate lawyer who is a frequent counsel and amicus in Trump-related rule of law cases in the Supreme Court and in other federal courts. Stuart has served in both Republican and Democratic presidential administrations as Assistant United States Attorney for the District of Columbia, Assistant Attorney General, and Acting Attorney General of the United States. Mark Zaid is a Washington, D.C. based attorney who specializes in crisis management and complex administrative and litigation matters, primarily relating to national security, international law, and diplomatic immunity. He represents many former and current federal employees, particularly intelligence and military officers, defense contractors, and whistleblowers. A mainstay on Washington's super lawyer lists, Mark teaches D.C. Bar CLE classes on related topics on privacy and security clearances. He's an adjunct professor in global security studies at Johns Hopkins and at Texas A&M's George Bush School of Government and Public Service. He is also a board member of Searle and executive director and founder of the James Madison Project, a DC-based organization that aims to educate the public on issues related to intelligence gathering and operations. Most significantly, perhaps, or relatedly, the ABA Journal once described Mark as, quote, an equal opportunity thorn out to pierce the sides of suit jackets bearing both elephants and elephants and donkeys on the lapels. All previous administrations took Mark's thorns in stride, as we would expect, but not the Trump administration. In early February, Mark was one of the attorneys who was targeted and had his security clearance removed by the current administration. So we're going to start with you, Mark. Why don't you tell us a little bit about what landed you in this hot water, a little bit about your practice and what got you there, what happened, and what you're going to do now, if you would.
Sure. Thanks, Mitch. So at its heart, as I learned from getting malpractice insurance when I used to say I was a national security lawyer and they had no idea what I was talking about, I'm an employment lawyer, but I'm an employment lawyer for spies, American spies, people who work at the CIA, the NSA, the DIA, all the three-letter agencies, and I help them when there are issues, both classified and unclassified, with dealing with personnel issues, security clearances, disciplinary actions, IG investigations, having their manuscripts published to make sure there's nothing classified in them. And I've been doing this for over 30 years. I challenge government accountability in every administration. Most of the time, it never involves the President of the United States. It's just going up against the agencies. And in the first Trump administration, I continued to do what I always do. And I was co-counsel for the intelligence community whistleblower whose complaint led to the impeachment of the President of the United States. Now, we had three objectives. One was to make sure the information got to the proper oversight authorities lawfully, no Ed Snowden-like behavior, which we accomplished. The second was to make sure there was no retaliation against the whistleblower, objective successful. And the third was to keep the identity of the whistleblower anonymous, and that was successful as well. No fourth objective as to impeachment. That was a political decision. It was anything we ever advocated. But apparently my participation as a lawyer and co-counsel, I didn't even start the case. My colleague did. I came in 5 weeks into it when it became public. But apparently that has been enough, and other cases I have handled, to put a target on my back by the President of the United States, so that I was in the first group of people, of lawyers, who were targeted to have my security clearance revoked, which I've had for 25 years without any issues whatsoever. In fact, in the first Trump administration, a year after the whistleblower case, I represented another whistleblower at DHS, Department of Homeland Security, who is the most senior whistleblower we've had in modern times at the acting undersecretary level. And the Trump administration increased my access to what's called TSSCI, the highest level clearance one can have. Obviously, there are other compartments that are higher than what I had. But a year after, right? So they knew about my representation the first time, and yet that's what's being cited as the reason why I'm suddenly not trustworthy or outside of good judgment. I am, if you look at the list of people, which are pretty luminary, the former President of the United States, the former Vice President, Secretaries of State, Deputy Attorney Generals, they're all political people. They're all either Democrats mostly, but some Republicans like Adam Kinzinger and Liz Cheney, but they were elected political officials. I am the only pure lawyer, independent, neither Democrat nor Republican, who's on this list, who just simply fights back against the Trump administration. And I am also the only one who actively uses my clearance in order to, frankly, protect the national security interests of the United States, whether that's as a defense lawyer or as an employment lawyer in trying to handle these types of cases. So even though in February they notified, well, they gave an interview to the New York Post, that's how we found out that we were targeted, and then a tweet by the Director of National Intelligence, and then finally 2 months later, official notification that my clearance had been revoked, although it was supposed to be consistent with existing law, which meant I was supposed to have due process, a chance to respond in writing, a chance to appear before a panel, a chance to have a lawyer if I wanted at my own cost, a chance, of course, to be told what exactly serves as the basis for the revocation of my clearance, none of which has happened. I will be litigating that at some point. I don't know if 500 firms will sign on to help me. So if anyone's interested in helping and wants to sign on an amicus brief, let me know. But I'll be doing that. And frankly, all it's done is embolden me to fight back more. I likened it to, it's my red badge of courage of taking on this administration. So really, and I'll close with saying, the people that it harms me for sure, but it really hurts the federal employees who I would represent, who aren't able to find experienced legal counsel who deal with classified information for the last 30 years, never having been inside the federal government as an employee, to make sure that they act lawfully and they don't mistakenly do something that they shouldn't have. So they're the ones, Republican and Democrat, who unfortunately suffer.
Thanks a lot, Mark. Stuart, you have a lot of very high-level experience across different administrations. Can you give us some sort of historical perspective on this? This strikes most of us as entirely unprecedented. Can you tell us about any precedents and also give us your sense of the dangers that we're facing? Why is this as scary as some of us think it is, or is it not so scary and dangerous?
Well, with my tongue slightly in cheek, I will go back in history. I could go back to the Bible for literary references, but this is Palm Sunday coming up, and I'm reading. If you want to come to Chevy Chase and listen to me talk about that, there you go. Instead, I'll go to the other great source, which is Shakespeare. And this was a problem that Shakespeare actually considered. You'll all remember Henry V, Part 2, the inestimable Dick the Butcher. Knowing that the law was going to be enforced against people like him and that they would hang, utters the very well-known but generally misunderstood statement that the first thing we'll do, let's kill all the lawyers. Well, that's not about what most people think that it's about. What Dick the Butcher recognizes, and what the good professor just alluded to, is that if you eliminate the lawyers from the system, you're going to eliminate the ability of individuals who have valid claims and defenses from bringing those things. And that's exactly what we're facing today. The first thing we'll do, let's kill all the lawyers, is something that Roy Cohn could have whispered in Donald Trump's ears, and President Trump liked that sort of thing. So he's, just in a nutshell, what these policies of the administration and the specific targeting of law firms is intended to do is attempting far more than depriving individual lawyers of the ability to practice or focus on individual lawyers. It's depriving their clients of representation by lawyers who might win for them in challenging Trump overreaches. Large businesses who can't be true to the economic needs of their shareholders by challenging the administration. There are cases all over the place. I'm a professional amicus these days, filing briefs in support of parties in probably more than 25 cases. Just as Mark talked about individuals, the sort of people he represents, not being able to find representation. Of course, these cases and challenges affect them tremendously, but some of these challenges that might be raised by corporations and other large entities affect us all, and not in a metaphorical way, but actually in an economic way and otherwise. And so this is a very dangerous situation, and fundamentally, the authority of government has been ceded to lawyers who misunderstand who their client is. Both the current Attorney General and the utterly unqualified interim and nominee to be U.S. Attorney in the District of Columbia, a particularly important place, have in their own testimony announced their fealty is to the president as an individual, not to the people. They've made it very clear. They're there to support the president. I was the nation's chief legal officer at one point, and just to share with you an anecdote, when I was asked by President Clinton to be the acting Attorney General, I'm a creature of the first Bush administration, and President Bush one, President George Herbert Walker Bush, was a close friend of mine. And when President Clinton asked me to assume the role of Attorney General, I talked to President Bush, and I said, you know, I'm responsible for a lot of things that went on in your administration. Do you want to hear about any of that stuff from me? And he said, no, just do your job. This is not about party. This is about the country. And unfortunately, we have people in office who don't see it that way. They not only see it as a matter of party, they see it as a matter of personal fealty to a single individual who is not dedicated to the rule of law. We live in 1938 redux with an America's first movement, with withdrawal from alliances, with making ourselves an unreliable partner, with attack on institutions like the organized bar, a feature that we saw in Nazi Germany. And we see the conditions with tariffs, whether they're on, off, or whatever, that are creating instability, much in the way that the Holy Smoot tariffs did in those days. So we live in very dire times, and when our interlocutor asks, what can we do about it, it's up to you. The cartoonist Walt Kelly, Pogo, those of you old enough to remember that, had a famous strip where Albert the alligator and Pogo the possum are talking, and Pogo announces with a tear in his eye, "We have met the enemy, and he is us." And in terms of remedy to all of this, there already is significant buyer's remorse. We have a very divided country. A lot of it has to do with technology and the displacement of people from traditional jobs by that technology, depersonalization. It shows up in anti-immigration feelings in this country, but it also conditions that are obtaining throughout the world. We see it in even countries like Sweden, Turkey, Hungary, add to the list. But this is one feature of it. Our interlocutor announced a few of the law firms that have been charged, particularly by the administration. What he didn't say, but could have, is that 4 more were added yesterday at the end of the day, and they're among the largest law firms in the world, in the United States, but necessarily because of that in the world. And at least a couple of them were filled with supporters of the Trump administration. So there's no loyalty, there's no gratitude, but there is a great deal of danger, and I'll pass for now.
Thank you. Thanks very much. Gary, in your current role, you're a client of big law firms. How do you see these recent events, and how does that affect both your client, without, of course, speaking in particular terms, and how does that affect your sense of the representation that you're likely to be receiving?
So it's interesting, I'm an in-house counsel for a bank. When these things first started coming out, my thought was, while as a lawyer, I certainly was very concerned. In my role, I thought, well, this probably isn't going to concern me very much. I don't have security clearance. I don't need security clearance. I'm not with a law firm. And I don't need my outside counsel to have security clearances. So it was something that I thought probably wouldn't affect me that much. And then I started reading some of the things that were coming out. And one of the first things that I was reading was the amicus brief that was filed by current and former general counsel. I counted 67 individuals who signed on to that amicus brief. Of the 67, only 4 were current general counsel. So that told me immediately that this was not something that people who were in-house or in-house with companies really wanted to put themselves out there for. And of the 4 current general counsel, only 2 identified who they were associated with. And when you look at it a little bit more closely, you realize that even in my position, what these executive orders is doing is creating a lot of potential risk even though you would think that I wasn't directly in the line of fire. One thing is, it requires government contractors to disclose whether they are using any of the firms that are subject to these executive orders. And, well, who's a government contractor? It isn't defined. But there is, a school of thought that says that any financial institution that is FDIC insured is a government contractor. And there are always, with all the different financial relationships, you will probably find that somewhere within your institution, there are going to be what could be considered federal contracts. So that puts us directly at risk in terms of having disclosure obligations. In addition, there are some things in some of these executive orders that prohibit the attorneys who are affected from entering federal buildings without escort or something to that effect, which means that if I have retained a law firm that is subject to this executive order and I've got a hearing in a federal court, there is a chance that my attorney may not be permitted to enter into the federal courthouse. Because a lot of the things that are within these executive orders are undefined. We don't know how they're going to be enforced, and so that's going to be a risk. So in addition to the concerns that I have just as an attorney and the ethics of the things that are going on, even in my position where I am not at a law firm that's affected, I do not have security clearance. I don't need outside counsel with security clearance, and yet there are still very significant ways in which this could affect me as well.
Those are really great. Thank you all so much. I'd like to ask a question about Big Law's response here. They're not the principal wrongdoers, obviously, by the long shot, but a lot of people have been criticizing the response by those firms that didn't fight. Paul Weiss, Skadden, et cetera. Paul Weiss probably got the most of the vocal criticism as being a long-standing Democratic firm. You got to fight these things. You can't roll over, is the main criticism, to which the firms that rolled over respond, what do you expect us to do? What could we do? In the case of Paul Weiss, Brad Karp, the managing partner, says, we wanted to fight, and we called other big firms and said, fight with us. Let's present a united front. And far from fighting with us, Karp says, other firms tried to steal our clients, calling the clients and saying, you probably want a firm that has security clearance, now wouldn't you? They have an obligation to their attorneys and their employees, they say. You folks have any thoughts about this? What ought big firms to do? Ought we to be critical of the Paul Weisses and Skaddens of the world? Or ought we to think, well, they really could hardly do otherwise? Stuart, would you like to start off?
The large firms are divided into two camps. The one camp with the most firms in it are firms that are withholding participation directly in challenging the administration, even when they are the targets of one, or especially when they're targets of this order. And the list, there's now 9 of the largest law firms that are subject to this, and largely they're settling. Donald Trump is bragging about these things, announcing that, to quote him, that these firms have paid me, he's made it personal as he does most things, almost $1 billion. To do so-called pro bono work, which is defined, there's an old saying, there are 2 kinds of people in the world, the good and the bad, and the good decides which is which. Well, it's the administration that decides which is the pro bono activity that's worth following. For tariffs, for example, which is a big issue on the agenda, which most people familiar with economics argue is antithetical to the interests of the American people. So you have this one category of large firms that have readily settled, haven't fought, and otherwise are hiding out, and others that are uncharged that you've never heard of that are doing the same thing because they represent large clients, particularly with respect to deals, large economic activity in the mergers and acquisitions area, and they're afraid that not only are they going to lose their clients, but their clients aren't going to be able to do these deals because they'll be challenged by government agencies on grounds both real and imagined. Then there's another category of firms which are smaller and essentially litigation-oriented. And those are the ones that are stepping forward. Williams & Conley is a good example, the firm of my old friends Edward Bennett Williams and Paul Conley. And so there are a lot of firms like that. And the other thing that we're seeing are organizations like some of the ones that I'm involved in, who are amici. In other words, we're supporting in court the interests of firms like Perkins Coie. I'm an amicus in their case, and you know, that's the lay of the land. I mean, as in most things, most people want to stay out of the fray, and they try to survive. And then there's a much smaller category of people who are willing to step in, and then there are a bunch of people who are safe, people like me who are old and economically well off, that we can do this almost as a hobby because it's satisfying, I assure you, to challenge arbitrary and unlawful activity. So that's a summary of what we're seeing out there. It's becoming more and more dynamic. I mean, more and more clients are realizing that their interests are imperiled, and so they're empowering their attorneys to act. But there haven't been all that many profiles in courage written among large law firms.
The initial tack on the law firms were because of select lawyers who had been in the law firms and mostly had already left for cases that they had brought earlier. One of the more recent ones actually was the first time we saw, because they had solely acted as lawyers in the Dominion voting case. It wasn't even something that there was a specific lawyer in the firm who they were targeting, that Trump targeted, looking to be, as anti-Trump. It was just literally for their representation of what we do on a day in, day out basis. And, I'm sure we can all understand the economics of some of the decisions, of how it could impact them. I think, though, at most I saw some of it would impact like 25% of their bottom line. I would hope for 25%. You'd step up and fight, but I'm not in that posture either. It's my law firm. I can do whatever the hell I want, and I'm happy to continue the fight. But to me, it reminds me of that famous poem from World War II by the anti-Nazi pastor about, they came for the communists and I didn't speak up because I wasn't a communist, and they came for the Jews and I didn't speak up because I wasn't Jewish. But then they came for me, and there was nobody left to speak up. So if the lawyers and the law firms don't speak up, there's not going to be anybody left to do anything, because Dick the Butcher, and I call him now Trump the Butcher in all my tweets, Dick the Butcher was successful in launching his coup with his colleague because all the lawyers were killed. So obviously not a good thing.
As a lawyer and as an individual, I would love to see the law firms fight this. I ethically, professionally, I think it's wrong. As in my current role, I'm also a consumer of legal services. And so I can appreciate that these large firms are caught between a rock and a hard place. If I'm looking at getting representation from a firm, I have to think about what it means if the firm that I want to use is subject to an executive order. And I think most people kind of understand that. What I'm not sure I've seen as much of is the consideration of what it means if you're using a firm that has done a deal with the administration. Because there are potential conflict and ethical issues that I'm not sure is getting a lot of consideration by people. And specifically, if you look at Pennsylvania, the Rule of Professional Conduct, 1.7a, will say that a firm has a conflict if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. And that gives me concern. Is my lawyer going to have a deal with the administration that is going to impact its representation of my client if they're doing something that may be adverse to a government, an agency of the federal government?
Your lawyer does have that restraint. It's not implied or imagined. It's part of the settlement with the government. It's right in there. So that inherent conflict is present. You don't have to make some kind of leap of faith to find it. It's actually there. And that firm has an ethical dilemma, and it's insoluble.
And then there's also Rule of Professional Conduct 5.6, which prohibits settlement with restrictions on representation, and that's essentially what these agreements are. So while, certainly the firms that are choosing to fight their clients can be put into a difficult position where they have to look at, what they need to do. There's also equally potentially more difficult decisions that you need to make when you want to do business with and be represented by a firm that has decided to make a deal with the administration.
Any of you want to make a prediction on how these lawsuits turn out? If you're going to fight, you want to win, and winning is not in your hands, it's going to be in the hands of the courts. Are the Wilmers and Jenners and Zaids of the world going to win these fights? And if so, what does victory look like?
It's the latter question that's the material one, because they are winning. Courts are entering injunctions. The courts are performing the way they ought to. And many of the judges that are deciding these cases are Trump nominees. So we know about that. So the real issue is, will the administration adhere to court determinations? And we're facing that in a number of areas. An immigration case decided yesterday involving someone who was kidnapped, taken out of the United States to El Salvador, cases involving the termination of National Labor Relations Board and Federal Trade members and Federal Trade Commission members. We're seeing it in a lot of ways where the administration has sought to concentrate power. It's kind of ironic that these are Republicans who bill themselves as conservatives. I'm a conservative. And what we do is favor limited government, strict constitutional interpretation. These people are nothing like conservatives. They want to inject themselves in every aspect of American life. But as I say, there are many ironies. But the short of it is, the real question is the extent to which the administration is going to adhere to adverse decisions by the federal courts.
And so far, the courts the law firms have prevailed and obtained injunctions, but only on the parts, and they only challenged the parts of the executive order that interfered with their lawyer-client relationships, their access to federal buildings, didn't address the security clearances, of which they're supposed to be all suspended. For those of us who had our clearances revoked, which again is a small number, because most of them didn't have security clearances in the first place who were subject to it, although I also represent 8 of the 51 signatories to the Hunter Biden laptop letter who were the subject of the first executive order the night of inauguration for having dared raise concerns about Russian interference in the 2016 election, and their clearances were revoked to the extent that they had. Federal courts historically, since 1988, do not have jurisdiction over security clearance fights. So we're in for a different fight. What gives us the opportunity to proceed is this notion of no due process. And one of the more recent cases that the Supreme Court ruled on with the Alien Enemies Act and the deportation, some of whom said, oh, this was, and the White House said was a victory for them. Actually, I look at it a very different way, because there was a 9-0 part of that decision that said due process had to be applied before you deport these illegal aliens.
And the same thing is true with yesterday's decision,
Yes.
which also was a 9-0 with regard to the fellow who was taken ex of a court order to El Salvador.
I'm confident on that part of it, but what it ultimately looks like, the President of the United States ultimately decides national security decisions, certainly from a deference standpoint. And so that, I may be essentially, fighting to achieve nothing at the end of the day, which is fine, because it's all about ensuring the rule of law is permitted and followed, and due process is certainly followed. I'm not concerned that in another administration, whenever we get back to normal, whether that's Democrat or Republican, that I'll get my security clearance back. So it's keeping this administration in check, but then, as Stuart says, let's say the Supreme Court revises its view on a case called Department of Navy versus Egan about security clearance jurisdiction, because essentially what the Trump administration has done to myself and others is, hey, I don't think any Jewish people should have security clearances. I don't think any women should have a security clearance. I don't think any African Americans should have a security clearance. I don't think anyone who's opposed me should have a security clearance. And can a court adjudicate that when it's so blatantly, in fact, per the wording of the executive orders, although I only got a White House memo. I'm really insulted by that. I don't know why I didn't get an executive order. I got a memo. It says it is not in the national interest for us to have our security clearances. When we have our clearances adjudicated, it's because it's in the national security interest of the United States, not the national interest. The national interest is, do we have the Keystone Pipeline? Do we drill in Alaska? Do we do this and that policy that changes administration to administration? National security interests are supposed to stay the same, no matter who's in the White House, as far as trustworthiness. If you hearken back for those who saw the Oppenheimer film, I mean, that was real, what Oppenheimer went through in the 1950s, and it was actually because of that the due process that exists today has existed since the Eisenhower administration because of the Red Scare of, if you're associated with communists, even anonymously, you lose your clearance. That's not how the way the system's going to work. So I'm confident ultimately we'll prevail in enforcing the rule of law. Substantively may take a little bit more time.
I also think that it's a misconception that the administration needs to win these cases. They don't. When you look at what's going on, if you're a law firm, even if you haven't been targeted by any of these executive orders, if Doug Emhoff came to your office and said that he'd like a job, would you hire him? I think a lot of firms are going to think long and hard now about hiring anybody who could be an enemy of the administration. When you're targeting these judges who are ruling against the administration and they're talking about, filing articles of impeachment, does anyone really expect that these judges are going to be impeached? No, but at the same time, the supporters of the administration know exactly what that means. Then they're going, and there's a lot of harassment, there's a lot of threats, and so they're trying to intimidate the judiciary. There was a very well-written opinion in the Perkins-Coie case when the administration had filed a motion to disqualify that judge just simply for ruling against them. Not because there was really any bias other than they had ruled against them. It was a great decision, but again, I don't think the administration filed that motion with any hope that they were actually going to win it. I think it was more of an intimidation tactic. So, do I think that the firms are going to win? Yeah, I think the firms are going to win. Do I think that the administration cares if they win or not? I don't. I think that the message has been sent loudly and clearly, and a firm that has not even been targeted by this is going to think about that before they hire someone who may be adverse to the administration.
That's a great point. Thank you, Gary. I think that's a good place to turn over to ask questions. We have around 10 minutes left, and I'm sure that lots of you folks have questions of our distinguished panelists, and I'd be delighted to field some if anyone would like to. I saw a hand up here, sir.
With respect to the firms that have either preemptively agreed to provide pro bono work or who are agreeing to provide pro bono work to have the decision of these orders, I question whether that constitutes an agreement to give something of value to Donald Trump for acting in his official capacity. If that is so, I have a question about whether that actually constitutes a bribe, even if Trump, under the Supreme Court decision, is immune, whether the firms themselves are immune from in giving the bribe, if it is one, and whether in an action in which they're representing the Trump-designated pro bono clients, there's a grounds for disqualifying those firms.
The Supreme Court dealt with an issue much like this in a case of mine many years ago called the United States against Brewster. Brewster was a senator who was alleged to have taken bribes and defended himself under the speech or debate clause, an analog to executive privilege as applied to legislators. And the court said that that was something not within the scope of expected official duties. Brewster was ultimately convicted of taking bribes. United States, or Trump against the United States, is something of the opposite of that. I think the case is wrongly decided. I mean, you're right that this is a case of extortion or bribery, and if a similar benefit for economic advantage were part of a transaction that you or I engaged in, we might well be seen in the dock. I think it's unlikely that we're ever going to see any charges relating to that, and although we are going to see a good deal more of the administration claiming that there are inherent executive privileges or powers that are involved in its decision-making, including the foreign affairs power with regard to activities that are alleged to be emergencies. And there was some reference to the National Emergencies Act. Again, the Trump administration has, in my view, misused it. There's bipartisan support for my view in the Congress, but not much action. And I think that's the most that can be said. I'm involved in cases like this now, and there are victories to be had. But in the final analysis, we're going to find the administration at loggerheads with the judiciary and with other branches of the government. And one thinks to Youngstown Sheet and Tube, those of you who remember old laws, to the power of the court. And I think the future of the country in many ways is going to come down to what the Supreme Court has to say. I'm increasingly optimistic about that, by the way. I'll leave that for future discussion, but that's the most I can offer to you.
One thing I'd say is, I don't expect that there are going to be criminal prosecutions against the firms, and I talked a little bit about the ethical implications for some of the firms that are doing those deals. One thing that I'd also mention is that there could be ethical considerations for government attorneys who are following the edicts of the administration. They've been asked to basically, government lawyers somehow think that there's improper positions that are being put forward by opposing counsel, that there are going to be threats against them, against that opposing counsel, and whether those raise some ethical issues for the government lawyers. And that is not within the control of the Department of Justice. That would be in the control of the various bar administrations.
Let me just add a little to that, Gary. There's a fellow called Ed Martin, as I mentioned earlier, who is the interim United States Attorney for the District of Columbia, and also has been nominated to be the permanent U.S. Attorney. And he's the guy who dismissed all the lawyers that had to do with the defense of the riot and interventions at the Capitol. He is the subject of at least 2 bar complaints that have been accepted by the District of Columbia Bar. I am involved in one of them, as I was in the 65 Project's bar complaint in New York and the District of Columbia, which ultimately led to the disbarment of Rudolph Giuliani. So the bar ethics committees are very active in this field, particularly in the District of Columbia. And we may well see action within a relatively short period of time. Again, it's hard to know what the consequence of that is going to be, but it might disqualify some of these people from appearing in federal court, for example.
I think we have time for at least one more question over here, please.
He has a mic.
What can we do to protect those people who what can we do to protect those people who we are sitting here talking about protecting us, specifically the judiciary? We've seen attacks on them. It's how we started this meeting today, and I'd like to know what it is that we can do to help protect them. The U.S. Marshal Service, which I think currently protects them, is under the executive department. I've heard of threats to remove and cut that agency, which really leaves judges with absolutely no protection whatsoever. What can we do?
And that's a huge problem, right? So we think about the powers of the judiciary. They can impose criminal contempt, but president can pardon anybody subject to that. They have civil contempt, which they can actually put people in jail for, but who would enforce that? Because that's the U.S. Marshals, which is part of the executive branch. So we're right back to, everybody trying to figure out why does Donald Trump have a portrait of Andrew Jackson in the White House Oval Office, of all people? Well, because historically, it's somewhat of an urban myth. I don't think there's any actual proof of it, that when the Supreme Court ruled against him in and around 1832, he said, yeah, you and what army are going to enforce that decision? And that's where we talk about constitutional crisis. We could argue, depending on where you sit or stand, whether we're in a crisis. Some love what the situation is now, others obviously do not. The true constitutional crisis to me is what Stuart's referring to, is when the administration refuses to abide by a federal court order, which the New York Times was reporting today. He just did to the district court in Maryland with respect to one of the deportation and bringing back one of the individuals. But that's just a district court, but we'll see what happens when it gets up to the Supreme Court. What can we do? This is where my power has always been as the lawyer to be able to bring these cases. And right now that works. We can bring the cases and achieve something. But if the administration refuses to abide by it, I'd love an answer to that question too, because I don't know.
I'll say just a couple of things. Don't get your hopes up. I'm not going to say this is the thing to do. Ultimately, our fate depends upon, I think, a relatively small number of persons. I think it depends upon some numbers of Republican members of Congress getting some backbone and doing the right thing. And in the appropriate cases, it depends upon at least 2 of the Republicans on the Supreme Court standing up and issuing the decisive judgments against this administration. I think it really depends upon a relatively small number of people. But those people, especially people in the first bucket, are not immune from the pressures of all of us. We still, ironically, to quote the title of a book by Justice Neil Gorsuch, it's a republic if you can keep it. We still do have a republic. And individually, we are weak. Collectively, we are strong. And as these events show, it is hard, though, to remain united and collected in the face of an administration which is set on dividing and separating the herd, taking one by one by one. It really depends upon, at each occasion when you have an opportunity to raise your voice in an effective way, if there's something to sign, if there is a demonstration to participate, if there is some money to give, and if there are elected representatives to call and call and call, especially if you happen to be a constituent of one of the representatives, either a member of Congress or a senator, who a Republican who could make a difference. So I think ultimately feeling some fortitude by ourselves in being steadfast and doing the right thing, even if it's going to be painful, and those of us who might have a little bit of a disproportionate power of influence on those who can make a difference, exerting it at every opportunity and not losing steam and losing hope and getting frustrated, as we will. We are going to get frustrated, we're going to lose, and we are not going to see the successes the way we want to, and we have to know that going in, and we have to keep fighting and fighting and fighting.
The title of Neil Gorsuch's book is a quotation that was of a statement that was uttered pretty close to here, in Philadelphia, by Benjamin Franklin. He was asked, following the Constitutional Convention, by a woman, what have you given us? And his answer was, a republic, if you can keep it. And it, yes.
So with that, we're going to take a 10-minute break now. I'd like to thank all of our panelists for a wonderful discussion on this topic. Thank you. Thank you so much. Great conversation. So we've got a marvelous panel for you following our previous discussion about attacks on law firms and the rule of law. This is another kind of attack on the rule of law, but switching to a somewhat different subject. It has to do with use of the military. We have seen over the past several months dramatic changes in the use of the military. Following the declaration of a state of emergency, practically the minute that Donald Trump came into office on the southern border, the deployment of NORTHCOM troops to the southern border now numbers nearly 10,000. We have seen the beginnings of a transformation in what we call civ-mil relations, that is the relationship between the military and civilian law enforcement authorities. We are going to talk about some of the traditional restrictions on use of the military, a concept called posse comitatus, and how some of the traditional restrictions on the use of the military may be starting to erode or be directly targeted. We've also seen extraordinary firings in the military, that individuals who try to stand up and object to the use of the military are being dismissed and fired, and dissent is becoming very difficult. On the intelligence side, of course, which we're probably not going to touch on too much today, we're seeing the signal gate, the casualness in classified information, but along with that, the reason I mention that is that along with that, we're seeing a kind of atmosphere of investigation terror polygraph tests being administered within the Pentagon is creating a sense of fear among military officers and the rank and file, and everybody is sort of walking on edge, sitting on edge. And so we're going to cover a number of these different topics with some very extraordinary folks to lead our discussion here, all of whom I should say are members of the Searle Executive Board, the Searle Advisory Council, or affiliated faculty, and that is the general theme for all of our panels. So first to my immediate left is General John Altenburg, who was for 28 years an Army judge advocate. 23 years he has been off counsel in Greenberg-Traurig in the DC office, a national security professor at GW Law School. He is also a member of the Searle Advisory Council. Next, out of order. Next we have Professor Kevin Govern. Kevin is Associate Dean for Academic Affairs and a Professor of Law at Ave Maria School of Law. He was an Army Judge Advocate General for roughly 20 years and is known, as I was first told when I met Kevin, as the lawyer's lawyer, the lawyer we lawyers and law professors go to when we really need the advice of a military lawyer. He is a longstanding member of the Searle Board. Next, we have Alberto Mora. Mr. Alberto Mora is former General Counsel of the Navy, after which he served as the Executive Director of the American Bar Association Rule of Law Initiative. He is also famous as someone who spoke out vociferously against the use of torture in Guantanamo Bay and placed his own career at risk to oppose the rendition, detention, and interrogation program. He is a member of the Searle Executive Board. Next, we have Dr. Steve Xenakis. He is a retired Brigadier Army General who has also served as an Army psychiatrist. He has worked with Guantanamo defense teams and is a widely renowned expert on matters relating to PTSD and a number of different issues connected with trauma and traumatic brain injury. He is also a member of the Searle Executive Board. And finally, Mr. Marcus Solar. Marcus joined Searle as Searle's new executive director. Just 2 weeks into the new position, we're delighted to have Marcos with us. He most recently served as the Deputy Secretary for Public Safety for Governor Kathy Hochul of New York, where he advised the governor on public protection and criminal justice policy, administering the state's $10 billion budget. I would say Searle's finances will be slightly easier to manage. Needless to say, we are delighted to have Marcos with us, and he is an expert in use of the National Guard, on which he advised Governor Hochul. So we're going to start with use of the military to address declarations of emergency along the southern border. So as I mentioned, the president declared a state of emergency on the southern border and thereafter began immediately deploying troops through NORTHCOM. Now, this happened as well in Trump 1.0, in which the president declared a state of emergency on the southern border, but things were a little bit different. At that time, you might remember, he went to Congress to try to get funds to build a wall. And Congress said, well, we'll give you some funds to build not a wall, but a fence, right? We'll give you funds, but much more limited funds. President Trump at that time was not happy with that result, and he thereafter declared a state of emergency in order to free up more funds to try to accomplish the building of a wall. The emergency funds that he thereby unleashed were insufficient to accomplish the task, but he was able, through the declaration of emergency, to free up more funds. He thereafter dispatched troops to the southern border, but they were very much in a supportive role, doing things like building barracks and supporting those who were working on building the wall, much less focused on immigration matters and more in terms of infrastructure support. Now, the dispatch of NORTHCOM troops to the southern border is much more focused on protection of the border, much more focused on lending support to Customs and Border Patrol activities, much more focused on accomplishing the immigration goals of this administration. And the number of troops vastly exceeds that which we saw in the first Trump administration. So I'd like to begin by asking our panelists to talk a little bit about this deployment and some of the tasks that the NORTHCOM troops, to the extent we know what they're doing down there, is this deployment within the president's emergency powers? Is he within his authority under the National Emergencies Act to declare such an emergency? And is the deployment of troops to the southern border within his rights under the National Emergency Act to use troops within this way? And let me start by asking General Altenburg to comment on this.
I'll start by saying that the president's emergency powers are extraordinary. There are lots of legislation passed in the 70s that granted the president emergency powers, so that every time there was something that happened in the country, whether it was a natural disaster or something else, they wouldn't have to get the Congress together to pass laws or to grant the president permission. So he's got extraordinary individual powers. I believe it was probably assumed at that time that whoever was the president of the United States would exercise that power, using good judgment and common sense. Having said that, I would say that he had the authority to do what he did in his first term, and he's probably got the authority to send troops to the border. Whether we'd all agree with that, whether even everybody in the military would agree with that, is another issue. The fact is, he has extraordinary power, and he's using it.
So the irony is that the National Emergencies Act, passed in 1978, was originally passed to limit the president's authority with regard to national emergencies. And it's done anything but that. It's really given presidents a very broad swath of authority to declare emergencies. Kevin, what are the limits on the ability of presidents to declare emergencies, if any? I would remind you, of course, that the tariffs are being imposed on the basis of a supposed trade imbalance emergency. And let's not forget, of course, that that President Biden invoked emergency powers to pass student loan reform. So this is not just President Trump. This goes way back. There were multiple emergencies that have been named over the years, emergencies that get named and then hang around. Are there any limitations on this authority?
Thank you for asking, Claire.
Just
First,
pull
an
the mic a little
apology.
closer.
My normally Midwestern nasally twang has a touch of laryngitis, so I hope you can still understand me.
Yes.
To build upon what my esteemed mentor, General Altenburg, had mentioned, since the National Emergencies Act was passed, there have been, every single administration has invoked emergencies. Carter twice, Reagan 6, George H.W. 4, Bill Clinton 17, George W. Bush 12, Obama 13, Trump in his first administration 11, Biden 9 times, and Trump so far in the past 3 months 7 times. Claire has already referred to another sort of emergency, the International Emergency Economic Powers Act, or IEPA, which is the basis for tariffs. Yes, at last count, we now have 145% tariff on Chinese products coming to the United States, effective immediately, and China has retaliated with 125%. We'll see where that goes. But let me address some of the metes and bounds of what can be done with the military. There are 150 different authorities the president can exercise, 137 of which are statutory and 13 congressional. That's even hard for a lawyer to keep track of, or I think they need an accountant to be able to help at that point too. But I'll give you one thing in particular of where past is prologue. One of the experiences that I had in my many of deploying during peacetime and war was doing post-hurricane relief after Hurricane Hugo in 1989, the very first instance of the deployment of U.S. troops since 1968 in the Watts riots. Then George H.W. Bush, invoking a national emergency, declared that there was the necessity to deploy federal forces to U.S. territory. There was essentially an insurrection ongoing. Therefore, being an exception to the Insurrection Act as well as the Posse Comitatus Act, and in fact, an entire brigade of military police, along with support troops and others, as part of an interagency task force, including the Drug Enforcement Agency and FBI, were in the U.S. Virgin Islands. Most people think about what had happened to Charleston, South Carolina. But about 90% of the island of St. Croix was either looting or being looted. Fast forward to Hurricane Andrew, that's the next time in which you have deployment of U.S. forces on U.S. soil. Many had anticipated that there might very well have been demonstrations that would take place after the inauguration. Thank God for the weather that we had. That might very well have been some kind of a quelling of same. But just as recently as this past weekend, you'll recall the hands-off demonstrations of several 100,000 individuals over all 50 states and in 6 different international capitals, which had the potential for the necessity of domestic deployment of forces and could have invoked foreign requirements for same.
So let's talk about some of the limitations, and we'll get to National Guard and demonstrations in a minute, but let's talk about some of the limitations. In the original National Emergencies Act, it was possible for Congress to override a presidential emergency with a majority vote. And in a case called INS v. Chadha, the Supreme Court found that that was unconstitutional because it took away the presidential veto. In the wake of the Chadha case, and then the National Emergencies Act was revised to take that provision away. So in the wake of the Chadha case, what can Congress do to override a presidential emergency declaration? And connected with that, is there anything in the fact that the National Emergencies Act says that the president may declare the emergency, but it doesn't specify whether or not there has to be already an existing emergency. Alberto, do you have any thoughts about that?
Well, I think the first thought that comes to mind is
Just bring that mic a little bit closer to you.
it can use the fiscal power. When you're in government, certainly at the general counsel level, you spend a lot of time making sure that any expenditure or activity is in line with authorizations and with respect to monetary funds, that there is appropriate express appropriations for that action. So I would be fairly sure that Congress could limit the president's authority to act by expressly limiting the use of money to authorize and then prohibiting it from other unfavored activities. That would be the first response.
So that would be the first thing, using the power of the purse to limit. Now, what about with the declaration of emergency, the president is able to free up emergency funds, but how much in the way of funds does he actually get through that? Do we have any sense of that, Kevin?
In terms of funding?
Through emergency declaration.
Through emergency declaration, the short answer is unlimited. Whatever authority the president has to be able to direct forces, there are going to be operation and maintenance funds that will immediately be invoked. There are other authorities as well, for instance, the Stafford Act for being able to support civil authorities where you have equipment and then you can man them. You're going to get into more of a danger zone when you have attempts to do law enforcement or attempts to enforce borders. But think about instances where defense support to civil authorities happens on a routine and recurrent basis, whether by an active duty force or a National Guard force. Really, I think the next question that's about to come is, what can we do to anticipate where the president will work with governors to have them use their money, OPM, other people's money, and the potentiality of governors being coerced into having their authority being usurped, and then having National Guard essentially being federalized and then sent to do authority.
So, and I'm going to stick with one more possible limitation for NORTHCOM troops before we get to the National Guard. Casting about here, and so far we're not coming up with much, are we?
Unfortunately not.
Right. So, so posse comitatus. So, and General Altenburg, I'm going to ask you, and then I'm going to go down to Steve Xenakis to talk about what federal troops are really well equipped to do on these missions. What is the concept of posse comitatus, and what restrictions does it place on troops?
Posse Comitatus Act restricts the military from being used in the enforcement of civilian law. It's an 1878 statute written in the wake of the 1876 federal election, where there were federal troops stationed at voting stations in South Carolina. I was probably in the Army 20 years and had taught it several years at the JFK Center for Special Warfare without realizing that it was probably racist based.
It has a racially based origin, but the interesting thing about it is that it serves an important democratic function of establishing a separation between the military and civilian law enforcement.
So there have been exceptions when forces have been used despite the Posse Comitatus Act, but there are specific predicates that there have to be before that can happen. And I was on the operation in Florida that Kevin mentioned, and there came a time when up the federal side and back down to, or up the state side and back down to us, they needed help to set up polling stations in Florida. And our people, of course, were ready to jump into that and set up 55 polling stations. It was going to require 55 GP medium tents and lights and generators. And I said to the chief of operations, "Do you know about the Posse Comitatus Act?" He said, "Well, yeah, I know about that." I said, "Do you know how it originated?" And he said, "No, how?" And I said, "Polling stations in South Carolina." he had an entirely different attitude about how he was going to implement that action and that operation when I told him that, because he was smart enough to realize, hey, that's a big deal. I mean, it's the same stuff. And so we had the National Guard do that, quite frankly. We did not have the 18th Airborne Corps or 82nd Airborne Division people do that operation. We had 10th Mountain Division down there also. We made sure that the Florida Guard took care of setting up those polling stations. We provided the supplies, but they did the work, and they were the ones that were guarding the polling stations.
So to make this clear for our non-military members of the audience, that means that NORTHCOM troops cannot assist with arrests. They cannot engage in detention of civilians. They cannot engage in Customs and Border Patrol activities. They cannot assist ICE in their roundup of illegal aliens and so forth if we are following the Posse Comitatus Act. Now, Steve, you've written about Posse Comitatus in the context of medical professionals, and you've made an important point about the fact that federal troops are really very ill-equipped to handle these kinds of tasks anyway.
Well, thanks, Claire. Yeah, let me just perhaps frame it in that as a physician, retired Army, and these kinds of activities that we call combat service support, which is that the medical, the logistical, the engineers, all those folks that really are we don't see necessarily as much on the front lines. We live in a somewhat different universe than those people who are in the headquarters or, in fact, the legal folks that are advising the commanders. Because on that day-to-day mission, we now have to take our service members, our soldiers, and we've trained specifically in scenarios that we feel we're going to plan for, and now guide them and put them in these positions so that they can support a mission that they have not at all heard about or understood before. And that gets to be very difficult, very, very difficult, and can fall apart. And obviously, probably the situations that you all are most familiar. I'm a Vietnam-era soldier. We saw how things fell apart during those years. We saw where people had been trained and disciplined and had not necessarily been given the most effective guidance, then went off and did things that we all know we really are backfired and are ashamed of. So we saw My Lai. And then if you look at that, what was it, 30 years later, time flies, we saw it again in Abu Ghraib, where, in fact, we brought into Abu Ghraib that prison reserve and guard forces. I mean, they're professional, they're committed, they're a very important component, but they're not necessarily trained for being able to work in that situation. There are clear shortfalls. I ended up spending a good deal of time there. Clear shortfalls in the medical care there. What would have been done, and that we knew that we were responsible as medical officers to do. And so we had obviously some very serious fallout from that. And I would say to you that I think we continue to see that in Guantanamo. So we really operationally on the front lines have many, many challenges in being able to deploy our forces to situations that have not been specifically planned for, funded. There is a commander on the front lines. There's a whole art form in terms of moving money around, as we call it, and that gets to be very troubling. We end up being held responsible for that, can be court-martialed. So there's lots of challenges. So a president can say something, a senior commander can say something, but then when it trickles down and gets to the front lines, we have a number of real ways that it will not be carried out as effectively as we think it should be, and in fact we won't accomplish what our goals and objectives are.
So this is, posse comitatus is not just a legal requirement, but it's also about using our troops in the most effective way, ways that they've been trained, missions that they can effectively support. And of course, there's also the issue of, while we're sending them down to the border and having them assist with Customs and Border Patrol and ICE and immigration issues, they're not available to take on other tasks. I want to turn now to make sure everybody understands the exceptions to posse comitatus, and one of them, and for this I'm going to turn to Marcus, is the use of the National Guard. In particular, the use of the National Guard in state active duty status. I think everybody should understand that the National Guard can be deployed in 3 different capacities. First, in state active duty status. Second, under Title 32, where they are still under control of the governor, but under those circumstances, their activities are paid for by the federal government. And third, they can be federalized, as everybody may understand, in which case they're under the control of the president. But Marcus, you advised Kathy Hochul repeatedly on use of the New York National Guard, including use of the National Guard in the subway system, use of the New York National Guard in prisons. Can you talk a little bit about the principle of posse comitatus, which does not apply in that setting, and what we're seeing now in terms of the attempt to corral state National Guards into federal support of immigration activities on the part of the federal government?
Excellent. So the first thing to take into account is the fact that the National Guard, in the missions that you have mentioned, whether it is in support of the work in the subway, or whether it was in support of the Department of Corrections during a very difficult strike, play a role that was purely logistic support. They never engaged in pure law enforcement, and they never crossed that line. We trained them. They used to require a significant amount of training from the National Guard. Even those who were in the subway went through extensive training for weeks in preparation for that mission to make sure that their role was limited to supporting a law enforcement. The second thing, which is important to take into account from what you are saying, is that one of the reasons why you have to do this is to protect the National Guard, and I want to come back to this later, which is the National Guard, when it operates in these situations, often do not have immunity from federal civil rights or other provisions. So you have to be extraordinarily careful to protect your officers, to make sure that they don't get into situations, let's say in the subway or in a correctional facility, where you could put them at risk. And that entails not only the legal risk, but also, as you mentioned, certainly risk, psychological risk, exercising roles for which they are not prepared. And the final element, which is important, and I think we'll touch when talk about the federalization of the National Guard, is that one of the things that changes is the military code of discipline changes. If you are on a state active duty versus if you are on a federal status, that changes, and therefore the predisposition from the National Service members, Guard members, changes as well. They know that under one statute they operate under one premise, under the other statute they operate, under one provisions operate differently. I think the final thing I would say is one of the things that we know is that the federalization can be called forth by the president, for instance, but this very, as you indicated, but there are limitations certainly, not only to insurrection and other things, but whether or not the laws are enforced, which is the third provision that they can use to say, we don't have enough resources to enforce those provisions. But what happens is the logistics still must be provided by the states and require some sort of agreement between the federal government and the state not to limit the authorities that the governors have in that situation.
So to follow up on this, what we understand is happening, and some of you may be reading about this, is that at least 2 states have entered into agreements with the federal government to lend their National Guard to the Customs and Border Patrol efforts in the state active duty status and say, all right, we'll agree to let you use our Guard, and we're going to name the Guard as law enforcement officers. They will be under control of the governors, but the governors are willing participants in this. So this is, unsurprisingly, Texas and Florida have agreed to this. We understand that the New Mexico's governor has said no to this. And now, what is likely to happen when the president does not get his way with a governor who has said, you're not using my National Guard in this respect? You will notice a news item from the last couple days involving the New Mexican National Guard. Anyone see this? The news item is that the New Mexico National Guard has been deployed for other purposes, including traffic control, right, thank you. Traffic control, right? Presumably, we don't have any inside information on this, but presumably the governor of New Mexico is going to say, I'm sorry, my Guard is busy doing other things. They're not sitting around. And there's a tussle going on, and this is going to come through all of the states. All of the governors are going to be asked to lend their Guard to this activity. So, General Altenburg, what is a state governor supposed to do in the face of this, and what are the president's options in the face of a governor who says, no, you're not taking my National Guard?
Well, he could federalize them, but then he can't use them for law enforcement.
That's the thing, right? Right.
Yeah, and I would say also, since let's flesh out PC a little bit, posse comitatus. The military has always used posse comitatus. I don't mean in any legalistic sense, but just as they operate and as they think about it. We use posse comitatus as a shield. We don't want to mess around with that stuff. We're trained to kill the enemy. We're trained to go and fight wars for the country, and this distracts us from preparing for that if we have to do a civilian control or a law enforcement effort. It takes away from the time that we need to spend to prepare to defend the nation. So for us, posse comitatus has always been a shield, not a sword. I'll leave it at that.
Now, well, a follow-up, though. So if, for anybody, if the president says to the governor of New Mexico, you know what, you're not lending me your National Guard, I'm going to federalize them. And now he has federalized the New Mexico National Guard. She says, well, the joke's on you because now you can't use them for law enforcement. There is something he can do to respond to that, to overcome posse comitatus, and that's, of course, to invoke the Insurrection Act. And the Insurrection Act is another exception to posse comitatus. So does anyone on the panel want to talk about what happens if the president then invokes the Insurrection Act, and this is an enormous chess game over the use of these troops, and what restrictions there are on the use of the troops if that were to occur?
Well, I had commented on that earlier of how seldom that has taken place in the second half of the 20th century all the way through to the present. From my recollection, the Insurrection Act has not been invoked since your deployment, sir. We've not had a circumstance in which there has been a declaration of an insurrection. It is a very serious set of circumstances.
I think in Rodney King in '91.
It was used in Rodney King.
But then '92 is when we have Hurricane Andrew.
Yeah,
So
I don't think they declared. I don't think anybody brought up the Insurrection Act in '92.
okay, well, it's been used very, very sparingly.
But it's there, right? There's nothing to
there.
stop him. It doesn't have to be an actual insurrection from Section 253.
Case in point, circumstances, for instance, during the Black Lives Movement, that very clearly could have been a situation where it could have been declared to be an insurrection in one city or another, or some other kind of a similar demonstration. Had things turned violent this past weekend during the hands-off demonstrations across the country, then the president could have done the same thing that H.W. did back in 1989 in invoking then 10 U.S. Code 331 through 336 to deploy federal forces
Yeah.
to then have the exception to posse comitatus as well as Insurrection Act.
The classic way posse comitatus is dealt with is that the governor of the state says, finally recognizes, and this gets into political issues and everything, I can't handle this. And then he asks for help from the government, from the president. Then they make a declaration.
Exactly.
Okay? And the Detroit riots in '67 is a classic example. George Romney was a Republican governor of Michigan, and he finally said, I need help. And so the president then, said, that's an exception to posse comitatus, we're gonna do this. And they sent troops mostly from from Fort Hood. And then, and the military has a way of doing that and helping to do that where they won't be called back to testify and so forth. They're used as a force, and they'll have a Detroit policeman out in front who will make the arrest. Right. They still limit the amount of involvement they have in law enforcement. They're just there to march down the road and people get collected up, but the police make the actual arrest. And so that kind of thing happens. But it requires the governor to say, I need help. And quite frankly, if it's a Democratic president and a Republican governor, you got problems, because nobody wants to ask the other party for help. I mean, it gets that. In Florida in '92, we were coming up on an election. And the governor said, I can handle this. About 3 more days went by, and he says, no, I can't. I need help.
Well, and where we saw the clearest example of this was, of course, in Little Rock, where Governor Faubus refused to integrate the schools following Brown v. Board of Education. The Guard was loyal to Governor Faubus, and President Eisenhower called out the 101st Airborne to force the Guard to knuckle under to his federalization orders. But the difference was there was a Supreme Court order backing his use of the 101st Airborne to support that integration decision and his use of the military. Go ahead, Steve.
Well, and I would also ask Marcus to speak to it. Look, I mean, irrespective of what might be a rule or a directive, guidance, I can't fathom as this order comes down, that you're going to find a commander on the ground, not in one way or another, being able to put in place a number of constraints and rules about what can happen or not happen. You know, it's any infantry commander general I've worked for has been extremely astute and attentive to details about training their people for a mission, knowing what the left and right limits are for that mission, being able to protect them in terms of what they're doing. And in fact, my mentor, who was a captain in the 101st in 1957, went into exquisite detail of how the 101st went to Little Rock and what they could do or not do and how they were going to work with, respectively, the other law enforcement. So it's a scenario that we have to understand that in federalizing the force, it now falls under the command of the NORTHCOM commander, a 4-star, and then there's going to be a number of other commanders that will, one way or another, be able to put in place a sort of a set of plays about what's going to happen here, and they're going to be rather restrictive, hopefully.
So go ahead, Alberto,
Just
please.
a historical note on Little Rock. Eisenhower wasn't particularly favorable to desegregation and racial equality, but it was when he realized that if a court order was not going to be enforced in Arkansas, that represented the potential destruction of democracy. The courts had to function and their rulings had to be enforced.
Absolutely. So we've got about 10 minutes before I let audience in for comments and questions, and we've got about 250 topics left to cover, but I'll just pick 2, which is, we were preparing for this panel, I got more and more depressed because we kept pitching wilder and wilder hypotheticals at each other, and I realized they weren't so wild. And one of them was the possibility of cross-border activity with the troops that have been sent down to the border. And then I realized, of course, this cross-border activity has been threatened already, which is the use of drones to shoot at cartels that are on the Mexican side. Then I realized the president of Mexico has already responded to that possibility, and let's say she was none too pleased with the idea. But so let's pivot to the topic of presidential war powers briefly. Suppose that our commander-in-chief does order NORTHCOM troops to use drones to shoot at cartels over the border. General Altenburg, can you make some comments about the legality of that kind of activity, both from the standpoint of the War Powers Act and from the standpoint of international law?
I'm going to defer to the academic, really, because I take a more pragmatic approach to things like that when I'm advising commanders. Academically, Kevin, what do you think?
Well, thank you for the handoff, sir.
Yeah.
I appreciate it.
It's the least I can
No.
do, and I always believe in doing the
Much
least I
obliged.
can do.
God bless you. Well, we have to look at whether or not this is permissive or non-permissive. So let's take the non-permissive first. We identify a threat. By the way, using the jargon NORTHCOM, U.S. Northern Command, the United States under the Unified Command Plan divides the whole world not into military fiefdoms, but having military areas of responsibility. So when we say NORTHCOM, we mean a four-star commander who organizes forces to be able to respond to peacetime and wartime threats.
And you have 20 seconds, Kevin.
Okay, so we're fundamentally going to be violating Mexican sovereignty if we do cross-border operations to go after cartel. Can the president do it? Absolutely. And oh, by the way, no president since the War Powers Resolution has ever complied with that particular legislation, yet they've always, at some juncture, given this is a notification, but it doesn't comply with the War Powers Resolution. So a president could do that. Should they do that? God help us if we find ourselves in that situation, because there will be some serious repercussions.
And of course, every president since the War Powers Resolution was passed has declared it unconstitutional. Yes. And I doubt that Donald Trump will be any exception. What about with respect to international law? And maybe, Alberto, you have some thoughts about this. Well, Kevin already commented on the violation of Mexican sovereignty. But I assume that doesn't change because we might use drones.
No, I think it would be regarded as an act of war by the Mexicans, and correctly so. The president would have an excuse. It would not be a prudent thing for him to do, nor would it be conforming with international law for him to use military forces in that respect. But let me also note that the president has also threatened the predatory use of U.S. military forces in the case of Canada, Greenland, and Denmark in ways that don't even have the fig leaf of cartel operations as a target, simply the desire to acquire land just simply for expansion of national territory.
Right. So Alberto raised the topic of Greenland. So this is even a wilder hypothetical. What if the president decided to use U.S. troops to invade Greenland? Is that even in the realm of possibility? And
there's a 1951 agreement between Denmark and the United States. If Denmark is unable to defend Greenland, then we can increase a troop presence. So this could be done incrementally. The notion of the camel sticking its head under the tent, and all of a sudden you've got the camel inside. More likely than not, this will be an incremental versus an overnight invasion kind of matter. And we certainly see how unpopular that visit was. And oh, by the way, as of yesterday, the commander of Patufic Space Base was relieved because of her intemperate and impolitic comments. So, very controversial topic.
Yeah, very important.
And I think that would possibly shatter the U.S. military. I think the dissension in the ranks against an unlawful and unwarranted use of U.S. military force for these kinds of purposes would be more than troublesome to the senior leadership of the.
So
An awful lot of people would be involved in that before that ever could happen. He can want to do that all he wants, and even some of his secretaries could want to do that. But there are lawyers all the way up and down the line And it would, if nothing else, it would slow it down. They'd have to account for that. They'd have to account for the lawyer to the chairman. Forget the civilian general counsel, no offense, Alberto, okay? There's military lawyers at every level. And some of them, you know, if not all of them, are gonna say, whoa, wait a minute. And they'd be advising their commander, this is unlawful. This is an invasion of their sovereignty. And again, there may be ways around it, as Kevin alluded to, but it's not going to happen as quickly as the president would want. There's going to be a huge slowdown.
So we've
as
got
that happens.
4 minutes for this last topic, which this segues right into, which is the firings in the military, which have been coming apace. And we see military lawyers, the top JAGs were all forced to resign, the chairman of the Joint Chiefs. There was mentioned before an atmosphere of real pressure and terror in the Department of Defense, as there is in many of the federal agencies, if not all of them. So where is this resistance going to come from when everybody is just going to lose their jobs? And we talked about law firms knuckling under in the last panel. And we also have at least, well, with law firms, we have many law firms who are also pushing back. And in the military, everyone who pushes back is getting removed. So anybody want to comment on the demoralization and the difficulty of pushing back in a chain of command that's operating like this?
First of all, what they're doing is legal, technically. The reliefs that they're doing, they have the authority to do that. It undoubtedly affects morale. I mean, they've taken out the head of the Coast Guard, the head of the Navy, the deputy head of the Air Force, and who's that? Chairman. The chairman, yeah. How could I
Chairman of the
forget
Joint
chairman?
Chiefs.
And also just recently, they took out the head of Cyber Command and the National Security Agency at a very delicate time, arguably, and the senior lawyers. And they have the authority to do all that. That's lawful.
And they're talking about changing training for JAG officers so that they are privileging lethality and minimizing the degree to which JAG lawyers are training on the law.
I believe, and I think that both Kevin and Alberto have personal experience with this, I believe that the culture of the JAG Corps, as they have developed since 1970 especially, will be able to withstand that kind of pressure.
I would like to just,
I firmly
as a-
believe that there are enough people that will find ways to see that we still uphold rule of law, we still do this right, we still brief soldiers right, and I have absolute confidence in the JAG Corps, no matter who is in charge of it.
I hope you're right.
I just want to, this is a serious problem. And those of us who've served have, unfortunately, been a part of it before. And we saw it after Vietnam, where our military and as field grade officers and senior NCOs left some of the, as General Powell said in his autobiography, some of the best left. We had a hollowed out army, we had a hollowed out military. We recovered, and we recovered after a number of years because we stood by and reaffirmed, I think as General Altenburg and Colonel Governor said, we affirmed our professionalism, but it was very difficult to understand what we were going to do that. And I give you two quotes that I was raised with as a young officer. There are times, as quoting from Ajax, there are times you could fall on your sword and you need to, but you can only do that once because you're dead. On the other hand, as my mentors said, and promoted to general, you have to be willing at a time to take off your stars and put them on the table and say, I'm not going to do that. And to know that you have colleagues who will also say that. And that's something that I think we can rely on. As General Altenburg was saying, that over the years, There is a core professionalism. I think, in fact, from the last session, the question, what can you do? And I think that the public can affirm that professionalism, and that's what we expect and respect in our military, and that we're going to do everything we can through the voices in the Congress to make sure that we're able to sustain it, and it will ground what we do as a military and as a nation. Thanks for the soapbox.
So we have 10 minutes for audience questions and comments. Please, Adir, we can get a mic down here. And please stand up when, yeah, thank you.
To what degree could the emerging major questions doctrine serve as a limitation on emergency powers under IEPA, the National Emergencies Act, or even the Insurrection Act, somewhat with what occurred in student loans?
The major questions
Major
doctrine?
questions doctrine.
That's been raised recently in the context of the Trump's exercise of tariff authorities, that in fact the Supreme Court, when in face of a challenge, and challenges have been raised to this, have indicated that there needs to be express congressional authorization in areas of major question doctrine, and arguably Trump's unilateral acts in imposing these tariffs without express congressional authorization for this would violate that doctrine. But in the military sense, I'm not quite sure how that would apply to the issues we've been discussing here.
Possibly with respect to the National Emergencies Act, but I'm not sure exactly the context in which it would come up. So one would have to think further about it. More questions?
Thank you. It came up during the discussion on the potential invasion of Greenland that order were given that military lawyers could say, no, 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 don't do that. There could be a breakdown in the execution of that order. I'm curious, is there a way to predict where those fault lines or divisions could break? Would it be more likely that one branch over the others would be less likely to abide by it, that one command over the others would be less likely to abide, that officers versus enlisted would be more or less likely to abide? Or is it hard to predict, impossible to predict where that breakdown and execution could occur?
Great question. Any thoughts about that, anyone?
It's hard to predict service-wise. It would depend on who's getting deployed, first of all, and what force was intended to be used. It starts with a lawyer at some level questioning it and saying we need to look at this more carefully. That alone starts to slow it down because the commander's going to be reluctant to take action. Ultimately, commanders make all these decisions. So, I mean, people talk about, well, the lawyer stopped them from attacking a certain target. No, they didn't. The lawyer gave advice. The commander made the decision. The lawyer said, what's the likely collateral damage? And what's the quality of your intelligence? And the commander asked those two questions of his staff, and he didn't like the answers, and he said, we're not gonna shoot at Omar. This was in Afghanistan in the early part of the war. And there, even people in the military, even people who later become political appointees from their military, carry with them the idea that lawyers make these decisions, lawyers write the rules of engagement, lawyers brief the rules of engagement with a commander to the troops. The rules are written at the top, at the 4-star, all the way down, sometimes at the presidential level. So when there's a rule of engagement that requires restraint, okay, that came from the top. That didn't come from some JAG captain, thought we really ought to be more restrained in how we approach this target. It's always commanders and operators making those decisions, lawyers providing advice, and if they don't like the advice, they can do what they want to do. They have that authority. A lawyer may not like it, but the lawyer's not supposed to take it personally. When the commander says, I hear you, but I'm going to assume the risk of doing this my way. And he's entitled to do that, or she's entitled to do that. I didn't really answer your question.
I think we have time for 2 more questions.
Claire, may I add something to the
Sure,
last question?
go ahead.
While it's perfectly, of course, possible to have a discussion merely on terms of executive branch and military branch activities, let's not forget that Congress has significant constitutional authority to set the rules for the military, and a lot of what we're discussing is taking the place of complete congressional abdication of its authorities to intervene and express its voice and its authority in how the military will be employed or not employed. And that's a problem. Checks and balances aren't working here as in other areas, as we discussed in the prior panel.
Of course, one of the big questions is if we did see Congress find its moxie and stand up on its hind legs and start to resist some of this, would the president actually listen to Congress, or would he override them, just as we're asking these questions about the federal courts? And of course, another issue here is whether or not, if federal courts got involved and started saying this is not a permissible use of the military, whether or not the president would listen to that as well. It's worth pointing out that as far as posse comitatus goes, it's a criminal statute, and the president now has immunity with regard to criminal statutes, criminal indictments. So it would be very hard to enforce posse comitatus against the president. Do we have any more questions from the audience?
I was curious about your thoughts on the Supreme Court opinion where they overturned administrative deference and said, well, the courts can decide these things, and the effect of that opinion on this whole issue and this whole area of military operations and what that does or doesn't mean.
DOD is not an administrative agency.
Yeah.
Department of Defense is not an administrative agency, first of all.
So,
It was against EPA, so I mean, it's still an agency run by the government, by the president, or conducted by the president.
So the argument is that does the shift in balance of power on administrative agencies have any impact on the Department of Defense? And I guess Kevin is saying it doesn't, because it doesn't count as an administrative agency. It's because it's directly under presidential control. It is commander-in-chief role. So I guess it doesn't, that division between administrative agencies and Oval Office control doesn't apply where the Department of Defense is concerned.
Yes, sir.
I was counsel for El Paso in that case.
Yeah.
And the district judge did exactly that. Found that the declaration of the emergency was pretextual, but the underlying issue was whether it is a separation of powers issue that's at the core of the case, and that is whether the agency, whether the Department of Defense can overrule a specific congressional appropriation. I mean, that's the fundamental issue, yeah. and some courts have held not, but it's a close issue. It's governed by Youngstown Sheet and Tube against Sawyer, and it's still a viable issue. But the answer is that one can treat it. And also, Claire, I would note, I'm litigating too many of these cases, that Loper-Bright doesn't just affect administrative agencies. It affects departments. Health and Human Services being the most obvious one, that various components of Health and Human Services are directly affected by it. What Chevron held was that where there was an ambiguity within a statute, that an agency of government, but that includes a department of government, was entitled to deference. Loper-Bright eliminated that, but it applies to any governmental department or agency's interpretation of an ambiguous statute. It's a limited universe that it applies to begin with, but it doesn't just affect
that's interesting.
independent administrative agencies.
Always something more to learn. Thank you very much to our panelists and to all of our audience questions. Thank you for a great panel discussion. So I'm very pleased for our third panel. We're going to talk about national security and advanced technologies, AI, robotics, and the security of our nuclear arsenals. And I'm very pleased to introduce my dear colleague, Dan Kotacek from the School of Engineering as our next moderator.
Thank you, Claire. Is this live? Oh, yeah, okay. I'm Dan Kotacek. I'm a professor of electrical and systems engineering in Penn Engineering. I've been working in the field of robotics for longer than some of you have been on the planet, from what I can see. And so it's my great privilege and pleasure to have begun to learn from Claire over the years how to think about the legal as well as the ethical issues involved in our technology. This session is going to be a little bit structured a little bit differently because there are so many technical issues that we won't cover them in any depth, but the design of the panel is to present. We have a very, very diverse and interesting, wonderful group of panelists today. I'm going to let them, Claire suggested, oh, you moderators, you could let the panelists introduce themselves, which is what I'm going to do. We have General James Cartwright, we have Mr. Jules Zacher, and we have Mr. Ben Farley. They have very, very different and very long-standing, deep experiences in these issues of a very orthogonal nature. And so I'm going to do my best shortly to get out of the way and let them discuss. The notion for the structure is, on the one hand, we're going to be spending some time talking about the technologies themselves. We're going to try to get some of the basic overlay of technical ideas out on the table, following which we'll try to have a 5-minute inter-panel discussion about the ideas. Then so the first idea will be led by General Cartwright, who will talk about the AI technologies, what they are, what they look like in the military, and then we'll pause and have a panel, a few remarks from the panel perhaps. We'll then shift gears and we'll talk about the nuclear technologies, and that discussion will be led by Jules Zacher. Once again, he'll get out some of the technical issues and some of the legal issues that he understands. We'll pause and have, within the panel, we'll have a few sentences, of discussion to get your appetite whetted. And then we'll shift gears away from the technologies themselves, focus on the technologies themselves, and shift to thinking about the nature of doctrine and training and what it will be like for our service members to engage these technologies in operational settings. And that discussion will be led by Ben Farley, who will talk about, he'll have a particular focus on issues of targeting. So it's my hope that we'll have not 10 minutes, but 15 minutes at the end. And so I'm going to give my panelists each a 1-minute warning before they're supposed to give way to the discussion. And then I'll give them a negative 1-minute warning, and then I'll be positively impolite, just so we can try to keep the time at the end for you to join in and ask questions. Okay, without any further getting in the way of my distinguished colleagues on the panel, I'd like General James Cartwright to lead us off. What is this AI phenomenon? What does it look like in the military? And what are the implications? Jim.
So that means that if my clock's running, I'm not going to introduce myself again. I think it's important here, and we've had several studies over the past 7 or 8 years looking at the challenges of maintaining a credible capability in our armed services, a capability that we can rely on, et cetera, and that is modern and dedicated to the national security mission. When I look at the force, both when I was in the service and now, there are two things that you look at. One is that there's a 3-generation activity going on. There's the younger generation just coming in, which is the bulk of the force. There's the middle management side of that equation. Think ages, say, 27 to 38, somewhere in that area. And then there's the senior officers. And to the extent that you can keep those generations on the same page, talks to the cohesion of the force and the ability to do all of the things you're supposed to do. as I was getting towards the end of my career, I can remember an instance when we went down to see the 3rd ID down in Georgia, 3rd Infantry Division. They were getting ready to head to Afghanistan, and we had put several new capabilities in at that time. The idea that we would have a software-defined radio and that most of the troops would be carrying something in the form of what we would call an iPad now, but some sort of device that would allow them situational awareness that they otherwise would not have. Situational awareness of the adversary, but also situational awareness of the intent of the commanders as they progressed through whatever operations they were doing. And I can remember if you are a senior officer, and certainly a Secretary of Defense in this case, when you visit an organization, you listen to what they want to tell you and what they want to show you for a certain amount of the time, and then you disrupt the whole thing by going where they didn't want you to go in an organization, or seeing somebody they didn't have all prepped out with all the right answers. And the Secretary was very, very good at this. And I can remember we rounded the corner in a squad bay building that had rows and rows of racks and people and whatnot. And of course, coming around the corner right at us, a young Army enlisted man around the corner. And once he got his heart to start beating again, talking to the Secretary in a 4-star, the Secretary said to him, "Okay, so what do you think of this new technology?" And there wasn't even a hitch. "I'd rather be without my rifle than without this," that radio and that pad. And the Secretary said, "How can you say such a thing?" And he said, "This gives me command and access to all of my supporting arms and my leadership and the intent. With that, I can see around corners, I can see over hills, I can do all sorts of things. With my rifle, it's just what I can see that's right in front of me." That kind of situation awareness was important to the soldier. What was interesting was the opposite was what we got from the 3-star commander, who said, "I think we'd like to just get rid of this stuff." That separation still exists, only more dramatic today. Okay? All of the polls that we do inside of the military that look at this kind of issue say that the distance between where the entry people are and where the leadership is farther separated than we've ever experienced before. Okay? Disruptive technology is just that. It's disruptive. It's disruptive in norms, regimes, policy, law. All of those things are going to happen. Process is the way we do incremental improvement, train people, give them a little bit more each time to answer problems and challenges we have. But when it's disruptive because incremental improvement is insufficient to get you where you have to be. Okay? Whether you're in business or whether you're in government. Okay? And right now the feeling is that we are sufficiently behind that we're going to have to turn to disruptive technology in order to be competitive in the environment that we're moving into, okay? And so what I'm going to offer to you here is to understand that, one, AI and robotics, interesting, okay? The tools that we need to do what we have to do they're in technology, they're in weapons, they're in organizations, they're in training. All of the pieces, all of the ilities are affected here. It's not just I'm going to give you an iPad or I'm going to give you AI to do something. It is the entire organization. What do people do? What does it mean to be a sergeant now? What are you expected to know? What did you get trained to do, et cetera? So you can't introduce a technology without all of those pieces. And that's absolutely critical to understand as we move forward. So as we think about a lot of this stuff, I just kind of go back to some basics here, but there are 5 domains today, okay? There's the land, there's the sea, there's the air, there is the electromagnetic spectrum, and there is space, okay? Those are generally aligned and created into services because services train and equip for those domains. But when you fight that force, those lines go away and they fight for a commander that's in charge of all of those capabilities. And that's called the joint activity. Today, 2 of those domains are almost exclusively autonomous activities because the human mind can't perceive the activities at the speed that they're occurring. Okay? I can give intent, I can launch something with intent, but the execution, the traveling to, the traveling from, etc., I can't see, I can't perceive, etc. In cyber, that's pretty easy to understand. Once it goes in there, it's speed of light. It doesn't regard borders. It doesn't regard property, etc. It moves to wherever it can go or wherever it's directed, and by whatever path it can find to get there. In space, the problem is latency. Okay? One, I don't have people in space. I have machines, I have sensors, etc. I have to be able to control them. I have to be able to integrate them. I have areas of blackout where I cannot talk to them, etc. Those are all challenges in those 2 new domains that heretofore we didn't really have with the other domains. Okay? But I've got to integrate them somehow, and that's been one of the most difficult things that we are trying to tackle and understand. So, the infrastructure that's necessary to do command and control and activities like command and control and the application of force kind of come down to a set here. And what's interesting about this set is that we've been working this for a long time, but it wasn't codified and it wasn't structured until the last administration. Okay? And the last administration did a set of things. First, there are a set of ubiquitous capabilities that are provided that are absolutely essential if you're going to have robotics, AI, autonomy, any of those kinds of things. The first is that you've got to have a global standard for position, navigation, and time. Of those 3, time is probably the most critical. Okay? That's called GPS for us. Okay? We have a GPS. The GPS that we originally fielded was good. The new GPSs that were funded in the last administration and are deploying now have a much better time standard, and it was absolutely essential to have if you're going to have a global capability. So that's point number 1, is you have to have that kind of capability, and it has to be ubiquitous all across the globe. Point number 2 is that you have to have a global network, okay? A dedicated, resilient, reliable global network. Not impenetrable, not absolutely spoof-proof or any of those things, because that's unrealistic. But think in the commercial world of something like Starlink, okay? Basically deployed all around the world. I can move into that network, and it doesn't matter where we have a problem, we'll have connections, okay? That's number 2. And then number 3 is a little harder to get our arms around, but essentially all of our processes, all of our training, all of the activities that we do in deploying and employing force right now is really constructed in a linear fashion. An if-then is what the generation calls it. You guys are all if-then. If, then I will do this. If that, then I will do this, okay? Almost everything that we have in the intelligence community, in the DoD, et cetera, is a linear activity. It was built and foundationed for the military off of Napoleon's organizational constructs of basically, I'm going to tell you what to do, then you're going to look at it and you're going to tell them what to do, and all the way down. And you know what that's like in the duty, grade school thing, and the line of people, and I start here, and what gets to the other end is always questionable as to how the interpretations went. So those are all critical. What we're moving to from the linear is a parallel activity. What the last administration did was give us the ground level how we're going to do that. And they pushed really hard on the PNT, the network, and then on electrical power, because we're dramatically underpowered as a nation. And then number two, on the global, how do you say it? Contextual understanding of a problem. So there used to be a thing called an OODA loop, how fast you could observe, orient, decide, and act. Now, I think it's just playing with words, but now it's sense, make sense, and act. Okay, fine, I got rid of a step. But the point of getting rid of a step was why? So things like cloud architectures and data centers was also a part of the last administration's push to get us to parallel activities. Now that we're there, you see the new edicts, I'll call them executive orders, that are coming out, and people are looking at that and going, oh, we're throwing everything out, we're going to start over again. No, essentially what they do is move us more closely to parallel. What is a parallel process or a parallel processor? It means that I am disaggregating where I'm doing things to many places, so for resilience, and I'm doing things simultaneously. Things that I used to do one at a time, I am now doing all simultaneous. A data center is the epitome of a parallel process, okay? We've now got those pieces. What this administration has given us basically is to take those pieces that we have in computational power at data centers and clouds and move it to the processes of the building, okay? How do I train? How do I start to act? How do I start to deploy with these kinds of capabilities? It's going to move people around. It's going to shift jobs. It's going to disruption. So those are the key underpinnings that have been put in place by the last administration in particular, and now by the current administration to move us forward.
Jim, here's a 1 minute.
Yeah, and I think, you know, at the bottom line of this is, this allows us to sense something, make sense of it, and then act at all levels of command and all levels of activity, okay? In timelines that we heretofore couldn't do before. We could not match up the speed of light in the cyber and electromagnetic spectrum with the speed of Mach 20, 30 to 40 in space to air, to ground, and to sea. We couldn't connect those things. We would schedule them, we would sequence them, we would deconflict them, but we couldn't basically act in parallel. What AI is bringing to us is the parallel activity. The guardrails on that right now, one is taken from the auto industry, but it is the science, or the SAE, Society of American Auto Engineers. 5 levels of autonomy. Okay, that is now being developed for defense. We work our way through those. We don't apply uniformly. Everything has to be autonomous. Some things are aids. Some things are to be done in sequence. It is through that guardrail that we're declaring what we are and what we want to do. When we build a system, we want this system to be, let's say, level 3 or level 4 or level 2. That is then taken up by the test community and tested to see if it actually works that way and if we can train people to those types of things. So those are critical kind of guardrails that we have to put on this thing. The test community has to be completely rebuilt. Because right now, the way the test community does, it's a very hardware-centric activity. The software side of this equation is really the dominant side. We don't get rid of the hardware, but I can't afford 15 years to develop the next capability. It's got to be more like 15 minutes to 15 hours. That's essential. And that's where we're moving to, okay? I got all of the things that...
Here's a negative one. Here's
the negative
1 minute.
I've got all of the, you know, the horror stories of the machines taking over the world. I got it, okay? But we're developing this. It's got its guardrails. It's moving forward. That's the glass half full story.
We'll hear more from General Cartwright. We don't have our 5 minutes. Jules, I'm going to move directly to you and ask you to give us a lead on the nuclear technology.
Thanks, Dan. How much time do I have?
I will give you a 1-minute warning at 4:49. I'm sorry, at 4:52 now.
52.
To give you
Okay.
your
All right, thank
your
you.
due.
So the only
Since
reason
I didn't do a good job.
The only reason I asked Dan that is I'm a trial lawyer, and when I go into court, particularly in an appellate court, you always ask the judge how much time do I have, right? So I have my watch here, and I'm gonna watch it. One thing I'd like to, Jim is an incredibly humble guy. This gentleman was vice chairman of the Joint Chiefs of Staff. He was head of STRATCOM, which is responsible for all of our nuclear weapons. He had incredible responsibilities, and I hope I don't embarrass you, but he's an amazing guy. So.
You're burning your time.
And we're thankful to have him on our Cyril board. Incredible, helpful. Anyway, my name is Jules Zacher, and as I said, I'm an attorney right here in Philadelphia. I'm a trial attorney in my daytime job. My real passion, quite frankly, is in the area of nuclear weapons and trying to get rid of them, all right? So that's where I'm coming from. I'll put my biases right out there on the table for you. One other thing that's kind of interesting, the building that you're in right now, the Union League, was, I believe, started right after the Civil War. And it's apropos because we're going to be talking about weapons and warfare. Sorry. So I just wanted to mention that as well. Let me get my glasses so I can read my notes. I would like to talk for a moment about artificial intelligence. And we've all heard a lot about it. We think we know what it means. But within the context of nuclear weapons, it's a whole different story. And what do I mean by that? So what we're concerned about in this community is eventually the launch of our nuclear arsenal, all of our weapons, would be taken over by computers. That's a scary concept, right? And again, I'm not being derogatory. I asked Jim one time, I said, how'd you come up from Washington? He lives in the Washington community. He said, I drove. He said, I asked him, what kind of car did you drive? I forget the name, the brand. He said, I said, well, doesn't that have automatic steering, you know, where you're not going to be in control? He said, yeah. He said, I didn't put my hands on the wheel the entire way up here. And I think to myself, holy Jesus, I mean, you know, this guy was head of STRATCOM. And anyway, so, but that's the issue, you know, do we want computers using artificial intelligence to control our arsenal? Now, the alternative to that, of course, you probably know this, something called sole authority, which means this President of the United States is the only person in our government to authorize the launch of a nuclear weapon. Okay, let that sink in for a moment. Okay, he's the only person that can do that. So the question becomes, do you want a computer to make that decision, or do you want President Trump to make that decision? I'll leave that up to you. But those are the kinds of issues, okay, that come into play with artificial intelligence. Not only is that an issue, but the question of something called deterrence, meaning the other side's not going to launch their nuclear weapons because they're afraid of what we're going to do in response, right? In this new world with artificial intelligence and the ability of these machines to think on their own, the whole concept of deterrence, in my humble opinion, goes out the window. Why? Because if artificial intelligence is in play, your enemy, unfortunately, always thinks the worst. He thinks you're going to do the worst thing, and he's going to respond accordingly. So my point is, with artificial intelligence, the possibility of this thing escalating right up the ladder until you start lobbing ICBMs at one another becomes much more possible. That's the world that we're living in. Let's return a moment to the idea of what they call man in the loop or person in the loop, the idea that there always has to be someone in the decision to make the launch that's a human being. So Congress is passing legislation, in fact, has already passed some legislation that requires that, right? That there always has to be a person, a human being, making that final decision. So I think these are the kinds of issues that I'd ask you to think about, because that's where we are. And these technologies that are being incorporated into our warfighting capability, particularly in the nuclear arena, in my mind, are really, really troublesome. I wanted to ask Jim a question, if I may. May I do that, Dan? Is that all right?
Absolutely.
Jim, you were in that. You were the guy, and he did interact with Obama quite a bit, actually. You're the guy in the room that Obama, whoever was president, would turn to, and say, "Okay, what do I do?" Right? I've got these missiles coming in, whatever. Maybe it wouldn't be as dramatic as that. You'd probably be a little slower in nature. But how would you advise a president, particularly in this new environment? We have artificial intelligence, if you will, at the very least, informing the decision to launch. How would you advise a president in that kind of a situation?
The critical commodity in the decision-making process is the availability of time to make the decision. How much time do I get? And usually it's never enough. And then the quality of the information that you're being given to make the decision, okay? And so with artificial intelligence, I can do two things. One is that when I was the commander of STRATCOM, I really campaigned hard to have defensive capabilities, okay? Because defensive capabilities give you decision time. If the ICBMs are coming over the pole and I've got a capability to defend myself against those, I do not have to launch or be forced and blackmailed into launching in order to survive, okay? So the critical part in my mind about AI is those two things. One is that it can run your defensive campaign, which is relatively straightforward. And two, it can give you a much better contextual understanding of the problem, as advice, not as I'm going to do this, but as advice. And it can do that inside of the very limited time that you have. Anybody who's been in those key positions in staffs or whatnot always know that you're dealing in tremendous ambiguity, okay? And the more you can work that ambiguity off, the easier it is for a decision maker to make a decision that in the end has a better chance of being the right decision. And so the tools of AI, I think, have to be centered on, one, the defensive things to protect and create decision space, and two, to give that space as much contextual awareness as possible. You have minutes in that scenario, okay? Minutes. Think of trying to gather all of the cabinet together in minutes, virtually or otherwise, not going to happen. Okay, so what does the president have to fall back on for advice? And you've got to make that as rich as possible and as quick as possible.
Jules, you have another 3 minutes coming to you.
Wow. I'm going to ask one last question, if I may.
Okay.
And thank God we have the leading authority here I can ask the question to, and that is targeting, okay? Can artificial intelligence help in the area of targeting? Let's take a scenario where we're in Ukraine, and they were talking, I know Biden's people were talking about using a tactical nuclear weapon just to send a warning shot or whatever to the Russians, we got to back out. How would artificial intelligence help in that environment, particularly, and I'm going to get a little nerdy here on you, where you have something called mobile launchers, right? The Russians have most of their ICBMs on what are called mobile launchers. They're not like in a silo someplace, they're moving all over the place. So you've got mobile launchers, you've got changing weather conditions, you've got all kinds of other issues, you have non-combatants moving around. How would you use artificial intelligence to help you target so that innocent civilians are not also hurt by a nuclear device?
The aspirational side of this equation, which is emerging both technically and in training, is to say that if I can understand the battle space, then the number of choices I have for how to handle an adversarial action is dramatically increased. So usually in national security, there are two areas that are very gray. There is that area between peace and first conflict. What are the tools that I have to forestay that and push it back towards negotiation? And then the transition from general purpose force to strategic or nuclear force. And presidents decision makers. Decision makers don't like to be boxed in with, I only have one answer for you. You want as many as possible because you don't necessarily want to, just because someone else has threatened nuclear or is even employing it, you don't necessarily want to be forced into that equation. There may be alternative capabilities that you can exercise that would be as compelling. And so it gives you more choices through the AI for targeting. And you say, okay, you know, maybe I go after launches, but maybe I don't want to go after launches. What's the deep context? And we rely on embassies and regional commanders and special operating forces and intelligence agencies to give us deep context into what does this adversary value, what can we hold at risk, and how can we hold it at risk. And the AI side of this is to bring that information right to the surface as quickly as possible.
Thank you, Dan.
Jules, that's great. You're doing a great job of moderating the panel. I'm so grateful to you. Okay, I think we're doing well. No, it's terrific. Okay, so now that we've introduced this question of targeting, I'd like to cede the floor to Ben Farley, who's going to talk about what it's like on the service operator end and some of the considerations that go into automated or non-automated targeting. Ben, and will you introduce yourself?
Yeah. Thank you very much, Dan. I'd be happy to. My name is Ben Farley. I am a visiting fellow at the University of Minnesota Center for Human Rights. I also have a job with the federal government, so I have to say this. I'm speaking in my personal capacity, and the views I express today are my own. They do not reflect the views of the U.S. government.
Is that some order, presidential order? Maybe?
No, it's standing. And normally, when I teach, I make a joke here about being able to say whatever I want at this point, but it feels like a dangerous joke to make these days. And now I get fired. I want to pick up on this question of targeting, and really, I'm interested in it from the perspective of international humanitarian law and how that gets embedded into AI-enabled weapon systems, what we might think of as lethal autonomous weapon systems. And so while Jules and General Cartwright have been talking about sort of the strategic activities, I'm really focused on and interested in like the tactical activities of weapon systems. And you know, a lot of the literature, a lot of the debate around AI-enabled weapon systems, lethal autonomous weapon systems, has been around the legality of using them in the first instance, or the ethics or morality of employing and developing them, and the ability or the capability of programming them to comply with IHL, international humanitarian law. And I just want to assume all of those questions away. Like, I assume that lethal autonomous weapon systems will be developed and will be deployed. There's good evidence for this already. And I assume that it would be possible to program or train a AI to comply with international humanitarian law. But really, those questions are really the first level considerations, because IHL is filled with underspecified rules, particularly when it comes to targeting. And what I mean here is that we have rules about who can or who cannot be killed on the battlefield that make sense in sort of an abstract or axiomatic way, but when they're actually applied to complex situations on the battlefield, even not particularly complex situations on the battlefield, they become themselves, the answers themselves become very complicated, and there appears to be a great deal of discretionary space for interpretation by the individuals that would program these devices and deploy them in the field. Let's take one example. Soldiers, members of state armed forces, are targetable at any time, anywhere that there is an armed conflict. Civilians, which are in IHL defined in contradistinction to soldiers, that is, individuals who are not combatants under the Third Geneva Convention, are civilians, are immunized against direct attack, unless and for so long as they engage in hostilities directly. In an international armed conflict, a state versus state armed conflict, this framework makes a fair amount of sense and is like reasonably workable, at least in the abstract. In an armed conflict between a state and a non-state actor, there aren't combatants. or at least there aren't combatants on one side of the battlefield because members of an organized armed group are not members of a state armed force. As a definitional matter, they cannot be combatants, which would lead you to the conclusion that they must be civilians, and to the extent that they're participating in hostilities, they are civilians who are directly participating in hostilities and might be targetable while they're actively participating in hostilities, but would be immunized against attack otherwise. But this introduces a problem of inequality of belligerence, where state armed forces are subject to greater lethal liabilities associated with armed conflict than members of an organized armed group. So IHL has developed a sort of consensus view that if you are a member of an organized armed group, that if you are a fighter whose job it is to fight for an organized armed group, you must be targetable as if you were a soldier. All right. The only problem there is that there's no definition for membership in an organized armed group. And there are at least 3 different approaches that one might take to this problem. One would be a very formal, restrictive approach that says that, if you have sworn some sort of oath to an organized armed group, you are a fighter for it, a member of it, and therefore you're always targetable. That's the historical American approach that tied targetability to authorization and affiliation with a public or quasi-public authority. There's a conduct-based approach that says you might be continuously targetable if you exhibit certain behaviors that we associate with membership in an organized armed group. This is the post-9/11 American approach, and it looks at factors like, did you attend a training camp? Are you riding in the back of a pickup truck with weapons in a place that is controlled by an enemy armed force, among many, many other factors? And then there's at least a third functional approach, which is the approach that has been adopted or promoted by the ICRC, that looks at the individual's role within a organized armed group's framework. Without expressing a view as to whether any of these 3 approaches is correct, the fact is that international humanitarian law today would seem to accept all 3 approaches as being equally lawful. Unfortunately, each approach would drive dramatically different results in terms of who might be targetable in a battle space. And it would either expand or contract the scope of people we might normally consider to be civilians, who would, depending on the framework applied, be exposed either as a first order or as a second order to the lethal consequences of armed conflict. And my suggestion is that, given the wide interpretive space that exists currently, the development of lethal autonomous weapon systems creates an opportunity not only for mischief, but a nightmare for accountability and compliance with IHL going forward, and opportunities for the proliferation of competing views of IHL, competing interpretations, based not on an evaluation, a normative evaluation of the law itself, but instead based on an evaluation of what weapon systems with somebody else's view of IHL already embedded in them might be the most adept for a particular battle space, the most cost-effective, or the most accessible. I'll stop there.
Very good, very good. That's great, Ben. My job is so easy today. It's really wonderful. I think what we can do right now is actually I'll give a few concluding sentences, and then I think what we should do is just throw the floor open, because I'm sure there are many, many questions that are, that we've begun to open that you might have an interest in following up on. What we've heard are aspects of the ambiguities and the difficulties of the decision-making itself, which we have the world authority here. We've heard about the intersection of those ambiguities and difficulties in the context of an intrinsically non-iterated exercise. The nuclear armament is not. We have, there's game theory, one-shot game theory, which is inapplicable, and the game theory that kind of works in the real world assumes an iterated set of games, but that's not what we have with the nuclear force. And so you've heard a little bit about that intersection. Then finally, we've heard Ben saying, let's suppose that we knew what we were doing on the programming side of the technology itself, and let's suppose that we had rules in place. The ambiguity of trying to interpret those rules in in the logic of human experience, much less in the machines, is challenging. That, I think we've covered a lot of the ground here. There's a lot that we didn't cover, but let me invite you to open it up with questions. And I'll start with the first hand up, sir. Go ahead.
So I have a fear of the development of AI more from a practical perspective than even the ethical perspective. And that is sort of like Cologuard ads. There can be false positives and false negatives. So you get the advice or you get the information from the AI, and there was a law case where a brief was put together by AI for a lawyer, handed it in, and AI made up the cases out of whole cloth. So even if you put a human in the loop, was it Plato who said to know the good is to do the good? But all we have to do is look around and say, that ain't so. So where do we go with AI? How do we rely on it?
Before I even get out of the way for our wonderful panelists, I'll point out that it's unfortunate that we're talking about AI or the AI, because there's 50 years worth of succession of ideas, and then even contemporaneously there are many, many, many different species of these technologies. I'm going to get out of the way. I'm going to suggest that we listen to General Cartwright first, then I think we'll move down the line to respond to that very apt question. Yeah.
So the difficulty here is, one is what information you provide. So we would not throw, let's say, AI alone into the room. We would basically define what kind of AI and what its parameters are, what the guardrails are. That's kind of point number one in that kind of a scenario. But the challenge that you have here right now, I think that you're kind of speaking to, one is this field is moving very, very fast. So anecdotal evidence from history is not a good guard. And so there is a very good work that has been done that was commissioned by the previous administration, but has been delivered to this one, that talks about software-defined warfare, okay? And it gets to the point that you are bringing out here of, okay, what's the pedigree of the data that was considered? Who else is looking at this and giving advice so that that data is interpreted in a certain way? The thought process right now for hard decisions is, I take what you've been presented at least for the last 10 days and just summarize it for you so that you can get a picture of what's happening on the battle space. I don't make the decision for you. I give you a set of options. And then your staff, whoever is available and whoever you want to touch, basically adds their perspective to it. But you're exactly right, in context is so critical. And so the funding in the current administration is really at the tactical and operational level, because that's where the need is, number one. Number two, in order to understand the context, please understand that there are weapon systems out there that have been out there for the last 15 years that are using what is classically called AI to make decisions about what the strike is long after you've pulled the trigger. Okay? And they have proven themselves. So the issue is, where are the merit metrics by which you would judge the decisions that would be made, and how many million times do you run those to make sure that when it gives you advice or information, that you're going to understand the credibility of it and have whatever trust you have. And I think that's the critical piece. We see this today in the automobile industry, okay? I can make a better decision than that machine could ever make. The problem is that machine has 1/10 the number of casualties that your car does. There's 100 funerals a day from people basically killing each other or themselves in automobile accidents every day, okay? We don't talk about how many happen with, pick it, Waymo, Tesla, whoever, okay? But it's dramatically less. What's the difference here between demanding a perfect system and understanding that you're dealing with an imperfect system and that it is advice? Getting those two separated is the tough part right now. And we know, last point, we know that building AI on rules-based coding doesn't work, okay? We have an institutional capability that is built into our government that deals with edge cases. So, you did something wrong, got it. That's black and white. But here is the edge case, and every case has an edge. And so we have these things called lawyers. And they look at these edge cases and they help us understand whether that deviation belongs in the group or not. You know, and so what you're seeing now in the science side of this equation is a hybrid between neural net decision-making and rules-based decision-making. And how we get that right and how we use that is just now starting to be understood.
Jules, why don't you?
Very, very quickly, if I may, to address your point about, the phrase is hallucination, right? That the AI comes up all this stuff that is not correct. It's crazy. And what bothers me more than anything is the current administration's approach to the accuracy, if you will, of artificial intelligence. And more specifically, the Biden administration has had a 34-page guideline. And a critical element of those guidelines in regards to artificial intelligence is that they must test the system. They must test it for the accuracy that it's generating. That they have to train the people that are using this artificial intelligence and putting it together. They have to be trained people. So guess what happened? The very first day that Trump was in power, he rescinded the order underlying this particular guideline. So that's out the door. The only thing the Trump administration has in regards to AI right now is we have to be the dominant power in artificial intelligence. That's it. And basically what they're trying to do is open up artificial intelligence to make the United States the dominant power in artificial intelligence from a commercial perspective. And the comparison, the juxtaposition of the Biden approach and the Trump approach is dramatic. And I think, in my humble opinion, it's very scary. So that's where we are right now. The whole concept of testing and the importance of international humanitarian law in regards to AI is out the door.
Ben, do you want to weigh in on this before we move to?
Yeah, I would just say quickly, one of the, I think, interesting facets of AI and the way we talk about AI is both as if it were one thing, which is problematic, but also as if it's the way it is added into systems or processes or weapon systems makes them all the same sort of thing and exposes us to the same sorts of dangers. And you know, Mitt Regan at Georgetown talks about this as a concept of a socio-technical process. And I think that's a really interesting construct and a way of thinking about it, particularly because you can sort of segment the process and look at AI's role at different levels of abstraction in the overall process and outcome, and you can define sort of constraints around the way things get employed or deployed. And I'll give you just a concrete example here. You know, as I was speaking a few minutes ago, what I really had in mind was like killer robots, right? Like the Terminator or like Predator drones that are totally, in the future, totally autonomous. It's hunting for enemies, destroying targets. But another actually deployed autonomous weapon system that exists today would be like shipborne automated defense systems that defend ships, naval vessels, against incoming attacks. And those things operate, they're turned on by humans, but they operate fully autonomously when they're turned on, and they're employed under like highly constrained conditions. And within those conditions, they are vastly more effective at defending a ship than a human being ever could, both in terms of like discriminating between like actual hostile targets and not hostile targets, and in terms of like building a wall of lead that protects the ship.
Yeah, they're very, very different species of these technologies that you're seeing. Mr. Zaid had his hand up, I think.
You guys covered it.
Okay, I see some.
The only thing I'll say is, Jules, you destroyed my concept because I thought I grew up from war games that the Whopper system would understand from tic-tac-toe not to launch nuclear weapons.
There was a hand right behind and then further back in the room after that.
With parallel computational capabilities in mind, what specific emerging technologies hold the greatest, for simultaneously enhancing lethality and also reducing significantly human civilian casualties, but like in, I guess you could say, urban warfare, such as we've seen in Gaza.
I think we'll start again with the general, and then we'll move down our panel.
So we talked about it a little bit here, but like the sea-based systems, you work with them, you get confidence that they work in that, then you expand their addressable target set, or in commercial terms, addressable market, however you want to look at that. As you get confidence with the system being able to discriminate, and it's the edge cases that drive this. It is not the center case, okay? And then the question becomes of how, it almost becomes a distance question. How far away, or when's that last human interaction occur, and how many variables could occur in that transaction in space? And that's the difficult part. I think the key technologies right now that we're really finding traction with is this hybrid between rule-based coding and neural nets, okay? That, along with having a set of ground truth data, I can now run any system with 2 programs simultaneously, so shadow mode. I run the one that is acceptable and already out in the field, and then next to it I run the next iteration of what's going to go out in the field. And anytime they disagree, it flags. And you can go look at the code and say, why did it disagree? Which one was right, in our minds anyway, et cetera. And you do that until you don't get any flags, and then you swap them over for a small group of testers that go out and hit the edge cases as much as they can. And then you open it up to the Mikeys of the world, that, you know, the guy that you, oh my God, what's he gonna do next? But the idea, though, is that it's a very structured transactional activity. It is not a, oh my gosh, look at this, really works well in the lab, let's throw it out there. You can't, it's just not principled to do it that way.
Jules, do you want to comment on
Just very quickly, to answer your question, 2 other technologies that I've been very impressed by, something called quantum computing, and hypersonics. So quantum computing basically, so normally in a computer you have, you know, an on and off switch. He's the guy that can probably tell a lot more about this than I can, but instead of doing it like that, it's simultaneously processing various pieces of information all at the same time. So the final result comes to you much quicker. And so, for instance, they're going to use it in trying to break codes. So when one country communicates with another and it's secret, they're going to be able to break that code to find out what the other party was saying. So that's called quantum computing. And the other one is hypersonics. And hypersonics basically, from what it sounds like, is a very, very fast system that it's very difficult to detect where it is. So this whole concept of the golden dome that Trump talks about, we're going to have this huge system overhead, we're going to prevent anything from coming in. I don't think it's going to work, particularly in regards to hypersonics. Jim, you want to comment on that?
I agree on the quantum. If you're not building your defenses with the mindset that quantum is probably already there and you just don't know it, you're behind the power curve, okay? But quantum won't be like a Big Bang theory. It'll be a little quantum here, a little quantum there, and it'll grow over time. But it's going to definitely drive the systems. Hypersonics, that is really thermal management, and we're starting to have some breakthroughs there that are going to be determinative. The hypersonics that the military talks about in aviation, as an example, are low. They're in the Mach 5 and below. And we pretty well understand that area. The area we don't understand well is about Mach 20. Right in that area, which is kind of where re-entry is, so hitting the atmosphere. We're today able to be out in that environment, but we can't persist in that environment. That technology is scary because that basically says that physically there's no place on earth that's more than about 20 or 30 minutes away.
And unless, okay,
Can
I
I
think
just
we'll
interject
move.
very quickly? I'm sorry, Dan, very quickly.
Give you, yes, what?
30
what is-
seconds.
yes.
One other reason that Trump wants Greenland, right, is because there's an Air Force base up there right now, and they want to increase the facility to deal with these hypersonics that Jim was just talking about. So that's another reason for we're going to take over Greenland.
I think we have time for one more question that we can handle.
Yes, sir. My question is to the general. So I'm a big fan of yours. I've seen you speak at the CSIS in Washington, D.C. in 2017. That was the first time I saw you speak. So since that time, I've been a big fan. So currently, I'm an airman. I'm serving with McGuire Air Force Base in the Air Force. So my questions to you now is, there's an agency called International Atomic Energy Agency. Is there like some sort of a synergy between that agency and the government in terms of collaboration and having an extensive network of cooperation to develop these technologies? How far should we go? Because whether you like it or not, there's money to be made all over the world and people are going to invest in it. So and then other countries are going to do it as well. Are there kind of, what should I use, like, cooperation between all these other countries of the world and the United States and all these other agencies as well in terms of doing it the right way, in terms of not going beyond what is not good for humanity? That's my question, sir.
We have 1 minute left, General.
And the question is really kind of from a humanities standpoint, what do you develop and what don't you develop, and how do you make your choices? Okay, I think that as a nation we have done that in the past. We made that decision with landmines. We made that decision with chemical warfare. We found alternatives. Okay, I think the challenge today is to understand what these new activities give us and capabilities, because I think it will affect whether we need nuclear weapons at all, and there are better alternatives than nuclear weapons, or whether we need them. I mean, those will be the kind of questions that are in front of us, but the nation has been pretty good about making those decisions. We're slow to act on them, unfortunately. I mean, people would like it to be that quick. We're not going to do landmines anymore, but you got to understand those weapons are there for a reason now, and you've got to replace it with something. You have to have something to come in there, and that's the difficult part. But yep, I mean, my card's on the table. I'd love to see an alternative to nuclear weapons.
I'd like to thank our panelists.
Give one more question, if I may, to you guys, because we're a bunch of lawyers here, and the legal side of this, I wanted to hear Ben talk about the international relations and legal side of this, which is the Council of Europe has produced the first potentially binding treaty to govern and control the proliferation of AI-based weapons and prevent a potential arms race in this regard. But meanwhile, we have the president's executive order, which is really going to already has started to spur the growth of AI and technological advancement in the administration. So I just wanted to give Ben a chance to comment on whether or not there's a tension there between international law and presidential executive orders. And I will say I have a secret agenda here, not so secret, which is my students are working on this for a briefing that they're putting together. Ben, could you briefly comment on that, and then I'll let us break up.
Okay. Well, so now I'm in the tough spot of being between y'all and rest from break. So I think, I'm going to dodge the question just a little bit and say that I think that, there's been a long-running process of, thank you, wow, that's much louder, under the framework of the Convention on Conventional Weapons to consider the legality of lethal autonomous weapon systems and their development and deployment. And that process has been unfolding for the better part of a decade and a half, a little bit more than that. And the group of experts convened within that framework have really been unable to agree on anything other than a very rough definition for lethal autonomous weapon systems, which is a weapon system that can employ human-like reasoning based on sensors. So that suggests to me that, along with like the history of international efforts to prohibit given weapons, suggests to me that it's very unlikely that we will see an international framework that actually prohibits lethal autonomous weapons, notwithstanding the efforts of the Council of Europe, unless something goes terribly awry as things are being developed very early, which may or may not explain. You know, I think it's hard to imagine the prohibition on chemical weapons, but for like the brutality of World War I. So, you know, if we see something similar, perhaps we'll see a convention.
All right. Well, thank you very much for letting me squeeze that question in, and we'll now take a break and come back in a little less than 10 minutes. Thank you. So for our last panel, panel 4, we're going to be talking about countering malign foreign interference in U.S. democracy, U.S. intelligence operations, past, present, and future. And I'm really pleased to turn it over to my colleague on the board, Jennifer Arbitier-Williams, who was former U.S. Attorney for the Eastern District of Pennsylvania and now is a full-time national security lawyer in the private sector, and she will tell you more about herself and the panelists. Please welcome the 4th panel.
Thank you. I'm so happy there are still people here. I knew that there was a risk at this hour we'd have an empty room. I'm also well aware that we're standing between you and cocktails. We will keep this interesting and lively and get you out of here on time, I promise. I'm also going to put my watch on the table. Try a lawyer trick. Okay, so you heard my background. I'm the former U.S. Attorney in Philadelphia. I'm currently on the board of Searle. I'm also an adjunct at Penn Law, where I teach national security investigations and prosecutions. Before I was U.S. Attorney, I was a national security prosecutor in DOJ for 15 years. So that is my perspective coming to this panel as a prosecutor. I'm going to ask everyone on the panel to just very briefly explain your background and how you connect to this issue before we start getting into the questions. We can start with Rob.
Thank you very much. I'm Rob Kellner. I'm a partner at Covington & Burling in Washington. I've been at Covington for 27 years. I lead the political law practice at Covington, and that includes the Foreign Agents Registration Act, FARA. So my touch point with this topic is principally through our foreign agents practice, national security law matters. FARA is enforced under the National Security Division, and so I advise companies and clients on compliance with that law and frequently end up defending them in criminal investigations or pre-criminal investigations related to national security laws, including FARA.
Thank you. Sean?
My name's Sean Carter. I want to say at the outset that I realized a little while ago that it's a mistake to agree to serve on the last panel at a symposium at Searle. I was given some pause when Stuart Gerson started quoting Shakespeare and talking about his work for 2 presidents, and then General Cartwright got up and piled on and talked about heading Stratcom. So I decided not to slink out the back door, but compliments to Searle. I am a partner at Cozen O'Connor here in Philadelphia. I do litigation work on behalf of terrorism victims suing foreign states and other parties under the Foreign Sovereign Immunities Act and in a terrorism act, and in connection with that, do a fair amount of lobbying work in a space where foreign governments and others are often opposed and inclined to engage in very aggressive efforts to influence U.S. policy and legislation.
Thank you. George?
My name's George Kroner. I'm a senior fellow in the National Security Program at the Foreign Policy Research Institute. I'm a former principal litigation counsel at the National Security Agency. My specialty, if there is such a niche, is electronic surveillance for foreign intelligence purposes, more specifically the Foreign Intelligence Surveillance Act, and more specifically beyond that, Section 702. I've written over 50 published articles on FISA, Section 702, and other intelligence-related topics.
Thank you. All right, so we're going to start with the basics, and that is by defining malign foreign interference in U.S. democracy. I'm going to try to call that MFI for sake of brevity. So George, how would you define MFI?
There's a working definition that can be found last year or last July, when we still had inspectors general. The Department of Justice Inspector General finished a report evaluating DOJ's efforts to coordinate policies designed to combat foreign malign influence in U.S. elections and defined foreign malign influence as subversive, undeclared, coercive, or criminal activities by foreign governments, non-state actors, or their proxies to affect another nation's popular or political attitudes, perceptions, behaviors to advance their interests. So that's, I think that's a pretty good working definition of what malign foreign influence is, again, coming from the Justice Department as recently as last July.
All right, perfect. So, obvious question, but why should we care about MFI? What is the biggest threat associated with it? Sean.
Sure. I think quickly before jumping to that, I think George gave a very accurate definition, and I think part of the issue is the question of whether you always know it when you see it. And in a lot of cases, it depends who the actor is, who's engaged in the activity, how they're going about conducting it, and what they're trying to achieve through it. And I think for all of us on one side of the spectrum, there are some very obvious cases, traditional espionage in the United States, or online campaigns such as those that have been organized by Russia to interfere with our elections. There are other subsets of activities that are of increasing concern, and one that came up in the news this morning that I saw arises from the Saudi public investment funds' efforts to take over functionally PGA and golf. And whether or not that kind of activity, perhaps aimed at sports washing, changing the viewpoints in the United States of a particular autocratic state, rises to the level of malign influence or not. So, I think the definition works, but you may not always know it when you see it. In terms of the biggest threats, the way I think about it is sort of that the environment we're living in is perhaps the greatest threat. The portfolio of tools that are available to foreign state and non-state actors to try to influence, engage in subversive activities is increasing and becoming far more effective, particularly in the digital space. That's occurring at a time when the population in the United States is increasingly inclined to obtain information from non-traditional online sources like social media, and where it seems to me foreign actors are, if anything, probably likely to conclude that they have been historically underinvesting in efforts to influence U.S. public opinion and policies, and the sort of reward for doing so is, apparent in an environment where there's a significant portion of the American public who believes that Russia was wronged by various parties and therefore had a good basis to invade Ukraine. So that combination of factors seems to give rise to a very significant risk that this activity is going to be heavily invested in by foreign adversaries, and that they're going to have digital tools, including AI, to carry them out.
Thank you. Rob, anything to add before we move on?
Yeah, well, the definition of malign influence is maybe the place to start. It's, in my view, it's very much in the eye of the beholder. The definition that we just heard is one that, you could view lots of different ways in lots of different contexts, keeping in mind that, every country on the planet is engaged in trying to influence the major powers on a pretty much continuous basis, and we're engaged in trying to influence every other country and their politics, and often their elections as well, on a pretty continuous basis. And so I've been concerned over the years that this concept of malign influence can be abused. If you go back 10 or 20 years, that was not really a term that colored the Department of Justice's approach to national security cases. It certainly was not a term that colored their approach, for example, to the foreign influence statutes like the Foreign Agents Registration Act. In fact, DOJ would go out of its way to say the opposite, that these laws are applied in an objective way to any kind of influence activity. It's not relevant whether it's malign or benign. But at some point along the way, over the last, I don't know, 7 to 10 years, this concept of malign influence found its way much more energetically into Department of Justice enforcement of these laws. I personally do not worry nearly as much about malign foreign influence. I think the actual impact on U.S. elections is close to negligible. And there are consequences of obsessing over foreign influence. The alternative is to look for very concrete activity in the U.S. that is actually doing something, not just speech related, and dealing with that, which we've always done. We go after espionage, for example, very aggressively, and there are lots of tools to do that. And the alternative is to go on offense, which is to deal with companies that seek to influence our politics by seeking to influence theirs, which we used to be pretty good at doing, and which we are very good at doing when our own democracy is healthy. When our own democracy is not healthy, we become vulnerable to foreign influence in a way that laws will not be the solution to. And when our democracy is not healthy, we become ineffectual at influencing other companies through public diplomacy. And so the more fundamental problem, I think, is sort of what's happening in our own politics and our own democracy. I think it can be a misuse of resources to focus too much on this amorphous concept of malign influence.
George.
Just 2 points, at least in terms of reflecting theoretically how our government views this. We had some talk earlier in the day about the National Emergencies Act, and I was surprised to find out that we actually have declared a national emergency with respect to malign foreign influence in our elections. Executive Order 13848, issued by none other than President Trump number 45, back in 2018, and renewed every year, as most recently by President Biden in September, so it's in place today, says the ability of persons located in whole or in substantial part outside the United States to interfere in or undermine public confidence in United States elections, including through the unauthorized accessing of election and campaign infrastructure or the covert distribution of propaganda and disinformation, continues to pose an unusual and extraordinary threat to the national security and foreign policy of the United States. So there actually is an executive order in place today that declares a national emergency with respect to the potential impact of foreign malign influence on U.S. elections and U.S. public opinion. I'd ask one other point in terms of the importance of disinformation and how it can impact things. It's not my normal nighttime reading, but I was reviewing the Senate Intelligence Committee's report, 5 volumes worth, on the 2016 election and Russian activities with respect to that election, and I came across the committee saying, recounting the largest ever study of fake news. Researchers at MIT tracked over 125,000 news stories on Twitter shared by 3 million people over the course of 11 years. The research found that, quote, falsehood diffused significantly farther, faster, deeper, and more broadly than the truth in all categories of information, and the effects were more pronounced for false political news than for false news about terrorism, natural disasters, science, urban legends, or financial institutions. The study also determined that false news stories were 70% more likely to be retweeted than accurate news, and that true stories take about 6 times as long to reach 1,500 people on Twitter as false stories do. So falsehood, there's a great cottage industry out there for it, And it says, as the authors of the study concluded, it seems pretty clear that false information outperforms true information.
This is why fiction sells better than nonfiction books.
Truth is boring. George, I'm actually going to stay with you because if we're going to counter MFI, first we need to learn about it, find it, identify it, and then we decide how we want to counter it. So can you tell us a bit about, to the extent it's public and can be talked about, what the intelligence community does to discover MFI?
The nature of cyberspace makes attribution of cyber operations difficult but not impossible. Every kind of cyber operation, malicious or not, leaves a trail. And the US intelligence community, analysts use this information, their constantly growing knowledge base of previous events and known malicious actors, and their knowledge of how these malicious actors work and the tools that they use to attempt to trace these operations back to their source. A variety of intelligence sources and methods are used for this purpose, ranging from highly classified collection programs like FISA Section 702 that I alluded to earlier, to actually to open source information. But while intelligence community efforts have improved in terms of identifying foreign malign influence, neither signals intelligence countermeasures nor information security efforts can stop malign foreign influence. It's out there. There's no way to build a dome over us, I know, and keep it out. So the most effective antidote in our open society is to effectively liaise with social media companies and electronic communication service providers to effect appropriate countermeasures based on the intelligence that we have collected. And until very recently, I should point out, as far as countermeasures are concerned, the Office of the Director of National Intelligence made these observations in connection with its intelligence community assessment of the 2020 elections. The second one, by the way, that executive order that I mentioned earlier mandates that within 45 days after any national election, the Office of the Director of National Intelligence issue an intelligence community assessment. First one was back in 2016, assessing those elections. So you'll see if you read those two assessments how the intelligence community has in fact refined some of its analytic techniques, and as it now recommends that defensive measures such as firewalls, up-to-date patching, cybersecurity training for government personnel, and separation of election-specific systems from other computer networks probably helped during that 2020 election season to thwart thousands of compromise attempts. So what the intelligence community is doing, as I say, it's getting better at recognizing these techniques, getting better, not at thwarting them. Again, it's difficult to do that given the scope of the activity involved out there. In my view, the most effective program here, again, if you want to be consistent with what the executive order is saying, is to liaise with the private sector in a way that allows social media companies and electronic communication service providers to take appropriate countermeasures, safeguard their systems, and for reasons that we'll get into and Jennifer, my co-panelists will allude to later, I am not optimistic about the future of government efforts in this area for reasons I'll elaborate on later.
Could you talk a bit more about FISA 702 and the role that you think that can and should play?
702, full disclosure here, from my sentiments about it, the most important foreign intelligence collection program operated by the US government. It basically functions by targeting foreigners reasonably believed to be located outside the United States to collect foreign intelligence. Those foreign intelligence topics, believe me, again, given the existence of the executive order, cyber activity directed at US election systems or simply cyber activity designed to influence adversely public opinion by spreading disinformation and malign foreign influence. What Section 702 can do is, to the extent that that is emanating from abroad, it can target the foreign actors. To the extent that those communications are with persons in the United States, those communications are collected, they go into a database, I won't even begin to try and describe the size of it for you, and it becomes available then to find and extract foreign intelligence information to combat this cyber activity. To give you an idea of the scope here, in calendar year 2023, there were 269,702 targets abroad, collecting literally billions and billions of communications. Now, one thing that can adversely impact the effectiveness of 702 in this regard is the only way you get intelligence information out of the database is to query it, run a Google type search against the database. For at least the last 2 reauthorization cycles of 702, there have been intense fights over whether or not a court order, the equivalent of a warrant, is required to search that database using US person identifiers. And the folks out there who are clamoring for a warrant are all of the view, the hypothetical that they give is the hypothetical of my friend Sean here talks to someone abroad, his communications are collected, they're in the 702 database. Why should his privacy be invaded without the protection of a warrant? Because according to all these folks, the FBI is just rummaging through the database trying to find bad people and criminal activity. Well, first of all, the last reauthorization last year prohibited the querying of the Section 702 database for evidence of criminal activity. It's a foreign intelligence collection tool. But the important thing here is, from the standpoint of malign foreign influence, the important US person identifiers here are not my name or Sean's name or Rob's name. They are US corporations. They are, Meta, Google, actors like that who's obviously are having their systems targeted by foreign enterprises and entities. In the last election cycle, the DNI concluded that the Russians, of course, had undertaken such efforts, that the Iranians had mounted a particularly intense effort to invade US election systems and, again, spread disinformation and malign influence. So the problem here is US person identifiers also include the names of US companies. They are US persons. So now, instead of the government getting information that would provide helpful information alerting such a company to the fact that their computer and cyber systems are being subjected to an attack or are being subjected to such influence, they'd have to go get a warrant before they could even put the company's name in the database, by which time, in today's day and age, the crisis has passed in the sense that the malign foreign influence has already been spread, the cyber attack has already occurred, and so for a variety of reasons, Congress did not include a warrant requirement. It'll come up again. Next year, 702 has to be reauthorized. And again, scope-wise, just to give you an idea, such a court order would have to come from the Foreign Intelligence Surveillance Court. It's the only court equipped to do that. It's 11 judges collected from 7 districts around the country, come in for 2-week stints in Washington and do their job, and then go back, frankly, to their districts and handle their full docket. Last year, or 2 years ago, 2023, that FISA court issued 357 Title I probable cause FISA orders. That was their institutional capability. They handled it all, but that's consistently what the scope of their work has been, 350, 360 orders. There were over 69,000 US person queries conducted last year by the 4 intelligence agencies that have access to 702 information. If you impose that sort of court order requirement, the FISC cannot handle it. It's institutionally incapable of handling it, which means the entire system breaks down with respect to that most valuable element, which is the ability to use 702 to alert US actors to the fact that they're being subjected to foreign attacks. So that's how 702 works. Whether it continues to work in that fashion and with that sort of efficacy depends both on the administration and frankly, ultimately next year on Congress when it comes time to reauthorize the statute.
So let's say 702 is reauthorized, queries are continued to be allowed, the intelligence community is doing everything properly to identify MFI. What do we do then? How do we stop it? That's a question that's come up from the group here. What can we do to stop it? I'm actually going to turn it over to Rob now to talk about FARA. If you could explain what FARA is and whether it is appropriately used as a tool for countering foreign interference.
Sure. So the Foreign Agents Registration Act, FARA, was enacted in 1938, originally to compel Nazi agents in the U.S. to identify themselves to the U.S. government. initially to the State Department, later the Justice Department. Think the Madison Square Garden rally, the Bund, other American German groups that were viewed as too closely allied with Hitler. That's what the statute was aimed at. It was used somewhat during World War II. It was used again during the McCarthy era. And then I would say fell into a very long period of disuse, near disuse, in which there were half a dozen or so cases brought over 50 years. It would be hard to find many other federal criminal statutes less enforced than FARA for a very, very long period of time. In fact, those of us who practice in this area, and used to be we'd get one question a year about FARA way back when, thought it was likely to be repealed at some point soon. And then just about that time, Robert Mueller sort of rediscovered the statute as part of the special counsel investigation of President Trump, and breathed life back into it. The statute essentially says if you are engaging on behalf of a foreign government or another foreign principal in certain kinds of political influence activities in the US, and other things that aren't really so much political influence activities, that you have to register and in detail disclose your activities through the Department of Justice. If you don't, it's a criminal offense and a felony. It's a pretty blunt instrument for use against foreign influence campaigns. It hasn't really been used very effectively against foreign influence campaigns. For one thing, in the digital age, it's quite easy to conduct a foreign influence campaign from beyond the borders of the United States. FARA itself, on its own terms, applies within the United States, and it's quite difficult to enforce outside the United States. We saw cases that were brought against various, Russians and others outside the U.S., but you don't necessarily need FARA to do that. You have lots of other tools you can use, and at the end of the day, the main tools the U.S. government has to use against foreign state actors are not U.S. criminal statutes, but military means, cyber means, public diplomacy, a whole variety of other steps that we can take when we want to deal with a foreign government that's engaged in that kind of campaign. So it's a tool that's available, but it's a blunt tool, and it does not have a particularly good or effective record of being used for that purpose.
Can you just bring the group up to speed about what the current Attorney General has said regarding use of FARA?
So Pam Bondi, who was herself a registered foreign agent, at least for Qatar, I think maybe for perhaps for other countries as well, I'm not sure. And knowing that, a lot of the lawyers in the FARA bar sort of wondered what attitude she would bring to the Justice Department on FARA. There were lots of theories on that. As it turned out, very, very shortly after she took office as Attorney General, she issued a memo that changed the department's approach to FARA, also changed its approach to the Foreign Corrupt Practices Act, and a variety of other statutes. And the language she used was interesting, because what she said in that memo is that we're going to revert to enforcing FARA as a statute to be used in cases of espionage or espionage-like activity, and essentially is sort of decriminalizing FARA violations from an enforcement standpoint in the absence of espionage. That's a pretty accurate description of the way the Department of Justice approached FARA prior to 2017, prior to the Mueller investigation. It was paired with another statute, 18 U.S.C. 951, sometimes referred to as FARA Light, which is often used to go after spies. You would sometimes see a FARA charge against a spy. You would sometimes see a FARA charge where there was some really egregious other conduct taking place, whether it be espionage or whether it be sanctions busting or something of that nature. And so the language she used suggested to me, and I think others in the FARA bar, that at least officially, she wants to revert to the enforcement posture that existed during that 50-year period of very close to zero enforcement, where cases under FARA were brought where there was, really serious espionage activity taking place, not influence campaigns, for example. I personally don't think that's an unreasonable approach to take, because I think FARA is an incredibly dangerous, easily weaponized statute, and I would be perfectly happy to see it repealed entirely. I don't think it's a good statute in any sense. What we don't know is whether the new policy of the Department of Justice will be applied in a neutral fashion or not. And this, again, goes to the heart of the problem with FARA. It's very broad. It's very loosely worded. It's vague. The courts have not deemed it to be unconstitutionally vague, but it is certainly vague. And it's a fundamentally political statute. That's the essence of the statute. It's focused on political activity. That's actually a term in the statute. And so whoever is in charge of the US government, whoever's in charge of DOJ, whether Republican or Democrat, has lots of opportunities to abuse the statute in ways that are perfectly legal. And so she's saying she's going to dramatically scale back enforcement of the statute. I wouldn't shed a tear if that were the case, but it will remain to be seen whether that actually happens. I mean, I'm defending clients right now in active FARA criminal investigations that are ongoing post Bondi memo. So I think it's too soon to say how that will actually be implemented in practice.
Thank you. Sean, what are your thoughts on FARA, its usefulness as a tool to counter MFI and the Bondi memo?
Sure. So I think in terms of FARA's suitability to deal with some of the online campaigns that we're seeing, it's not going to be an effective tool to deal with armies of bots being deployed by North Korea or Iran or Russia to influence public opinion in the United States. And that problem is going to probably get worse with AI, and that's not an area where I have any expertise, so I'll leave it to George to talk about that. FARA occupies a more traditional space, as Rob said, arising from efforts by the Nazis and communists to get agents in the United States to carry water for them and promote their ideas in the US and influence public opinion in their favor. I still think that FARA has an important role within that context, because there are still circumstances in which it's very important for foreign actors to deploy US persons to assist them and try and bring public opinion around to their view. And FARA operates as the mechanism to make sure the public is aware who is the author of this messaging campaign, what materials are they distributing in support of it, and what are they saying about it. It has essentially a couple components, as Rob said. If you're serving as a foreign agent, you have to register and identify yourself with the DOJ as someone who's working for, a foreign government on a political campaign in the United States. It has a reporting requirement that if you, in that capacity, are reaching out to folks in Congress, folks in the executive branch, you have to identify who you're talking to, who you're having meetings with, those kinds of things. And then it has a set of requirements surrounding materials that you're using to support those efforts, so-called informational materials and the like. And you have to file your informational materials with the DOJ so the public has access to them and understands what you're doing. And you have to label them and say that this advocacy is coming from a foreign government and the like. My personal experience and entry point to this was in relation to legislative work we were doing for the 9/11 community to try and persuade Congress to enact legislation that would enhance the remedies available to the 9/11 community to sue both foreign governments and non-government actors who are alleged to have aided and abetted Al-Qaeda in the decade leading up to 9/11. And not surprisingly, there were governments in the Gulf region primarily who were not supportive of legislation that would remove their immunity for claims of that nature, and they lodged a very aggressive campaign in their own right to try and stop it through 2016. After they failed through their own advocacy, Efforts were then undertaken essentially to recruit unwitting U.S. veterans to become their advocates. The program essentially involved first disseminating misinformation into the United States, indicating that the law would expose veterans to potential arrest and claims in foreign jurisdictions, to then encourage them that a set of revisions to the law and amendments to the law that just so happened to would immunize the foreign government actors from potential claims were the answer to this problem, and to then encourage them to visit Washington, boots on the ground campaigns to try and get Congress. The problem with this is that a lot of the people who were involved in it never registered as foreign agents. The materials they were distributing to veterans communities in the United States didn't identify that the advocacy information they were receiving was being funded and supported by a foreign government. And many of them who came into Washington on these trips had no idea that they were unwitting agents for a foreign government and that their trip was being paid for by a foreign government. So there is real exposure. When you have a circumstance in which you have hundreds of US veterans having been deceived into being unwitting advocates for a foreign government, you need a tool to fix that. And FARA is the tool that would have worked to do that if it had been enforced at the time. It historically has not been enforced. There's almost no staffing. There's been no money. The FARA unit did not have independent subpoena power or civil investigative demand power to conduct investigations. So, I agree that it's a one-size-fits-all statute that doesn't work as it's currently crafted, but there needs to be some sort of legislative effort to craft an appropriate tool to deal with the more insidious campaigns that have occurred and will continue to occur, particularly in an environment where it's not being enforced at all.
Can I respond to some of that? Sean's managed to mention a number of cases I've been involved in, so I can't address the particulars of those. But I will say, first of all, there was quite vigorous enforcement of FARA from 2017 until now, maybe ongoing. But you mentioned a lack of staffing. There were a lot of prosecutors all over the country investigating FARA cases, keeping me and others in the bar quite busy. So I don't really agree as a factual matter that it was, at least during that period of time, lightly enforced. But to really try to drive the point home to people in the room who may be sympathetic to, to the point of view that this is a statute that should be aggressively enforced, I'm sure you want it aggressively enforced against your enemies. Do you want it aggressively enforced against your friends? So to give you an example, there are people all over this country supporting Ukraine in all sorts of wonderful ways. I'm a big supporter of Ukraine myself. Are many of them violating FARA? Probably, right? Pick whatever cause you support around the world, whatever country you think is a victim and whose cause you subscribe to or who you think is an ally of the United States. There are people in the United States who share your view and who are probably running around violating FARA left and right. There are thousands of people in the United States in violation of FARA at this very moment. I don't know the actual number, but it's a very large number because the statute is extremely broad, far broader than people realize, and very susceptible to enforcement. We get off the hook because DOJ, picks its cases to go after. But if you wanted to have robust enforcement, this goes back to the point of what does malign mean, you're going to see a lot of friends going to prison because it's an easily weaponized statute for that purpose. If I wanted to support Russia's agenda in the United States, one way to do that would be to aggressively enforce FARA against supporters of Ukraine. And pick whatever other scenario you want around the world. We have friends around the world. We have enemies around the world. The statute's incredibly easily weaponized to serve any particular political agenda. So even if you subscribe to kind of the parade of horribles that Sean just listed, and I don't necessarily agree with all the factual claims, but some of those are matters I can't really speak to. Just keep in mind, you have to be prepared to see it aggressively enforced in situations where you're more sympathetic to the cause more sympathetic to the fellow Americans who are advocating for the cause, and maybe more sympathetic to the allied country at issue.
We did discuss in preparation for today that FARA is not the only governmental tool out there to try to punish those who are engaged in MFI. There's economic sanctions enforced by the Department of Treasury. There's other criminal prosecutions, other statutes that can be used. FARA is not the only tool. So it's really a question of whether it is a good tool or not a good tool for this. So big question. George, I'm going to start with you. Do you believe prior administrations have been effective at detecting and stopping MFI, and how do you predict this administration will compare, keeping in mind that the threat is evolving?
I believe that there were improvements reflected in the two intelligence community assessments, the one following the 2016 election and then the other following the 2020 election. You could see from those reports that the intelligence community had broadened its techniques, had become more learned and more nuanced in terms of its ability to assess the information that it had. And in fact, after the 2020 elections and the results found in the report with respect to Iranian activity and Russian activity, as you just alluded, Jennifer, the Treasury Department's Office of Foreign Asset Control issued sanctions against an element of the Iranian Revolutionary Guards and an element of the Russian GRU, the main intelligence directorate. Now, do I think that those sanctions have taken them off the table and they're not engaged in these activities anymore? Nothing could be further from the truth, which to me, again, exposes where you have First and Fourth Amendments in play, the ability of the government, certainly the intelligence community, and even FARA and OFAC and so on, to get a handle on this problem is very, very limited. To me, the most effective approach, and the government had gotten better at identifying when these attempts were made, when this information was in play, but liaison with private actors, social media companies, communication service providers, and so on, is really the only, in a constitutional democracy, the only efficient way, semi-reasonably efficient way, that the government can try and affect change in this area. You ask me what my projection is going forward. Well, the most important body involved in that liaison activity with private actors and the government was the FBI's Foreign Influence Task Force. Before she had her first cup of coffee on the day she took her job, Pam Bondi disbanded the Foreign Influence Task Force. It doesn't exist anymore in the FBI or the Department of Justice. So I'm not optimistic that this is a high priority for this administration. I'm not optimistic that any meaningful governmental measures, excuse me, will be initiated in this administration to further combat this policy or this problem, notwithstanding the executive order. Now, whether on their own, social media companies and electronic communication service providers take steps, that certainly is possible, and you'd like to think the government would support those efforts in as many ways as possible. Interfacing, for example, with the Cybersecurity and Infrastructure Security Agency, CISA, which is in the Homeland Security Office, or department, I should say. But I don't see CISA, as I'm watching Kristi Noem out there, I'm not finding a lot of encouragement that CISA's going to be sent out into the field to help protect in these areas. So unless the private sector acts more vigorously, I don't see improvement, and assuming this order is still in place when the report comes out, or should be out, frankly, shortly after the 2024 election, I think it's going to fall on deaf ears. So.
Thank you. I want to go to Sean next, but I do want to address, perhaps now or perhaps next, what the social media companies should be doing. Should they be putting out counter messaging? Should they just simply be alerting CISA? There are different tools that they could use. But Sean, why don't you give us your thoughts on how the prior administrations have done and what you're predicting going forward?
So, I think there was an increased focus on the problem and an increased effort to try and figure out how to deal with it. And there was, I think, as George alluded to, more work being done in partnership with the social media companies to try to figure out ways to police this activity, identify it, and address it. In terms of where we are now, George knows a lot more than I do about this, but I would not predict that the current administration is going to make that a priority in any way, and I would like to hope as well that the social media companies will do it on their own, but in an environment where they're not being strongly encouraged to do so by the government, I suspect that their efforts will wane considerably for all kinds of reasons, and that we'll be playing catch up at some point in the future when we decide to prioritize the issue again.
Rob?
Well, look, it is a fraught area to have the government telling or suggesting to social media companies that they should remove content from public dissemination. And I think it has really undermined public confidence, maybe not for the entire country, but for a significant part of the country, that the social media companies were in the position where they were receiving kind of regular feedback from the US government on what should or should not remain online. The Hunter Biden laptop episode ended up being a bit of a black eye, I think, for that whole process. I'm sure there are many other examples where the process worked well, and where there was, good foundation for advice that the US government gave to social media companies about particular social media campaigns. But I don't assume the government's always going to get this right. Certainly, I don't think the public assumes the government's always going to get it right. And so this is not a costless undertaking to rely on the government suggesting to the social media companies when a particular communication is one that should be removed. The other way to, there's lots of other ways to approach the issue. As I said earlier, I'm not as concerned about the threat posed by social media campaigns. I'm not as persuaded that it's going to materially affect election outcomes. I think there's actually very little data to support that, and there have been, various people have made efforts to try to come up with empirical data to show foreign influence social media campaigns having some kind of impact on election outcomes, and I really haven't seen any data that supports that. And in a First Amendment context, personally, I worry about having the US government providing feedback to publishers of any kind, including social media companies, on what they should or should not post.
So George, having heard that, and in light of what you said before, that you would hope social media companies would do something, what do you think should be done? Fix the problem, George.
Well, I didn't mean to imply, if that's the way it came out, that the government should be collecting information and then directing in any sort of way, issuing content-based instructions to the private sector. In fact, around 2020, I think it was, Missouri's Attorney General sued President Biden, or sued the US government, when the Biden administration sought to, in fact, implement what, in my view, were not even necessarily approaching content-based restrictions, but again, trying to improve the relationship or the liaison between the government and private entities. Actually, it managed to get a preliminary injunction out of a judge down in Texas. Ultimately, Missouri versus Biden was resolved when the Supreme Court decided that the Attorney General and the other plaintiffs didn't have any standing. But the point is, as Rob pointed out, there will be a resistance, private sector resistance, from various quarters and various groups who would actively oppose, I think, any strong government effort to get involved in more content-based restrictions. So I think that's a non-starter in this country, and which I guess leads me back to saying I don't have a solution for what to do about this. You'd like to have a more learned electorate, greater maybe a little better civics education in our school systems and so on, because the problem isn't going to be resolved by the government. I don't necessarily think it's going to be resolved even by private actors. They will be, as Rob and Sean pointed out, reluctant to take any sort of actions that would offend a large part of, their constituencies. So we're stuck with where we are, and the only thing that would goad us in the right direction, and by right, again, I don't mean content-based restrictions, just, letting some entity know that all of this activity that's taking place on their platform is in fact being generated by Russian bots or trolls or something like that. That's all, just that's where it's coming from. What they do with that information is up to them, and I don't think the government can frankly do much more than that. But this is, free speech is a problem of constitutional democracy, and when you can, in my view, characterize what happened on January 6th as some sort of free speech activity, I guess if that's where we are, we are. I don't see it that way, but, I don't have a solution for that either.
All right, we have 9 minutes until cocktails. Questions?
Okay, thank you very much. I liked the panel very much. I'm not going to ask about FARA. I learned a lot about FARA today, but I was going to ask something more general. And I don't have an opinion, so I genuinely want to an answer if it's possible. I would like to know whether the panel would agree, would support the cancellation of a national election on the basis that there is evidence that there has been a foreign interference of manipulation. For example, like in the case of Romania, the national elections were cancelled, and I think that they are going to be run again now in the month of May. Some people are happy, some, for example, in the European Union, because the winning candidate, whose election was cancelled, was pro-Russian, and some people is not. So I wonder, what is your opinion on this? Thank you.
Fraught question. How do you feel about canceling an election or postponing an election because of information regarding malign foreign interference? Anyone want to take this one?
As the election lawyer in the room, no, I would not support canceling an election. Fortunately, our Constitution doesn't really provide for that. Some other countries have a little bit more flexibility under their constitutions to postpone elections. I certainly wouldn't make any changes based on a foreign influence campaign, because as I said, there's very little evidence that foreign influence campaigns affect election outcomes in, at least in well-developed, vibrant democracies, or specifically in the United States. That said, what I worry about is something quite different, which is cyber attacks on election systems. That's a very real issue. I still wouldn't cancel an election, but the problem of what you would do if you had an election, a national election in the United States, and determined, let's say, within 48 hours after the election, that there had been some sort of systematic cyber attack that potentially impacted the impact of the election, the outcome of the election. That is a nightmare scenario that is not entirely far-fetched, due largely, frankly, to decisions that were made after the Bush versus Gore case in 2000, when there was sort of a panicked rush in the US away from mechanical voting systems and a desire to network and electronicize election systems, which I thought at the time was a serious error in judgment. And I'm a bit of a gadfly in election law circles on this issue and on some other issues, but I'm the Winston Churchill in the wilderness years election lawyer on this issue, that I keep saying this is a huge problem, and not many people think it's a huge problem. So I hope I'm wrong, but I worry much more about that and how we would deal with that than I do about a foreign influence campaign with respect to a particular election.
All right, we have time for a couple more questions.
Where does the forced sale of TikTok fall within this landscape?
George, you wanna take it? Yeah. Go ahead, you take it.
No, the digital space is yours.
To be honest, I don't feel particularly qualified to answer. My niche is a narrow one, and I don't see that as particularly an intelligence or an intelligence community issue. Where does it fall? I personally have always felt that that's sort of a dangerous, to me there was a stampede decision in Congress to reach the decision to do that, to compel the sale. I have never, to be honest, seen whatever data supposedly exists, if any, to suggest that TikTok's current owners are in fact in cooperation with the Chinese government with respect to compromising, U.S. person information or anything like that. So I don't think that's a good idea with TikTok, and I don't necessarily think, absent some sort of foreign, I don't even know what kind of showing I would require. I'm stumbling around here, so the answer, I ought to stop and shut up and say, I don't know the answer to that question.
Well, my firm actually represents TikTok in those matters, so I can't comment.
I'll give you the perspective of the teenage girls in my house, which is the problem that whatever the basis was for Congress to force that sale, it wasn't communicated in a way that's at all coherent to the users of it. And perhaps it's because they're basing it on information that they're unwilling to share publicly. But the people who use the platform have no understanding of why the government was engaged in the way it was, which is a problem. That does eradicate faith in the system when it's just not understandable.
I am hearing a theme that consumers need to be better educated about the risk of MFI. Everyone's getting their news from social media, and I think there needs to be a real education campaign so that people kind of know to be a little skeptical. One more?
Hi, this one's for past prosecutors.
Okay.
So given the special relationship between President Trump and Elon Musk, my question is, how could existing legal doctrine or new frameworks effectively assign liability to platforms like X should demonstrable evidence evince intentional tolerance or even facilitation of disinformation campaigns that benefit a political figure or a foreign faction?
Are you saying because Elon Musk is in government, does that mean that his business is not going to be prosecuted? Is that the question?
The question is just how a liability would be assigned or what would need to be changed, if anything, to the legal framework as it stands in order to assign it, given that relationship.
I will say this, I'm no longer in the Department of Justice. I believe in the Department of Justice, and I believe in the prosecutors who are investigating and prosecuting cases around the country. And I know that there's a lot of stress and strain on DOJ right now, but I believe in prosecutors doing the right thing. And when crimes are committed, I believe that they investigate and prosecute those crimes. So I was in DOJ for 20 years. I saw prosecutors bring really hard cases, and I saw prosecutors decline cases that shouldn't be brought. So if I could just give sort of a naive, perhaps very optimistic answer to that question, I believe in prosecutors doing their job.
So we're gonna break in just a minute. I'd like to get you guys to comment, and Jennifer's comment is a good lead into this. I feel a little bit like this rosy picture is, it wasn't all rosy, but a bit of a rosy picture on how our intelligence and the integrity of our intelligence community and how it works and how the Justice Department works and so on is a little bit like, debating Serbian, Austro-Hungarian relations in July of 1914. Because, 6 days ago, the head of the NSA was fired and his deputy or forced out, presumably, and there's no reporting on this because he would not go along with the Trump administration's plans for use of the NSA. We have a difficult history with regard to the NSA and a lot of controversy around the use of that agency for spying on Americans, we can say, or surveillance of Americans. A lot of controversy around the metadata program and so on. And presumably all this is going to ramp up a lot more, and we haven't had really a conversation about that. So just before we close, I'd really like to hear your thoughts about that and what we can expect going forward.
So when you say about that, are you talking about the fact that there have been these firings, or?
That they're going to continue,
Yeah.
and that this administration is probably going to engage in an awful lot of surveillance on Americans and a lot of privacy violations going forward.
Well, you know, I guess I don't like to make assumptions about the future. And as Jennifer was saying, I mean, look, there are thousands of federal prosecutors across DOJ who have bar obligations, or law licenses that they want to keep. This is actually something that I think the media have kind of not fully appreciated, but I actually worry more about non-lawyers in the government than I do about the lawyers, because the lawyers have, apart from their professional obligations, they actually have their livelihood on the line if they lose their law license. And so there are a lot of things that have to go wrong for the administration to be able to engage in, you know, unlawful surveillance, particularly on any large scale. My sense is that we will learn about that one way or another. My sense is that DOJ prosecutors will, you know, follow the law, and if they're receiving an unlawful order, they can find ways to noisily resign. I will say I've been surprised at, in recent years, when people do resign, how rarely they do that in a noisy way. And you know, this is a concept in professional ethics for lawyers, the noisy withdrawal. We probably want to see people who resign letting us know why they're resigning.
Yeah.
But I have a high degree of faith in the federal prosecutors that would be the first line of defense.
This is the optimistic side of the table.
This is the optimistic side, yeah.
No, I mean, I think the federal prosecutors is right. There's a lot of very good career people who are still there, and you know, they believe in the rule of law. I thought you were sort of getting at, you know, the question of whether or not this parade of firings and, you know, changing personnel within the intelligence community and other aspects of the government are going to impact the basic competence of the government to do some things that we needed
That's
to do.
likely as well.
Which is, you know, potentially a concern, and you know, I think there's at some point maybe there'll be a concern about people participating in administration if it creates some sort of legal exposure for them. You don't make a ton of money as a government employee, and the last thing you need to do is be on the wrong end of a prosecution at some point in the future. So, I mean, there are some concerns about those issues for sure.
George, last word on this?
50 years ago,
Speak into the mic.
50 years ago, there was a set of hearings in both houses of Congress, the Intelligence Committee, intelligence abuse hearings conducted by the Church Committee and the Pike Committee that disclosed some rather serious violations by U.S. intelligence agencies, including, Claire just alluded to, two NSA programs called Minaret and Shamrock, where the NSA was, in fact, spying on U.S. citizens. The outcome of those hearings and post-Watergate was the culmination of what I call, and I think others do in the business as well, the grand bargain, because there was talk at the time of literally disbanding the intelligence community. And the grand bargain said, Congress basically said, we will allow you, the executive branch, to continue employing a robust intelligence program, but you will now do so under guidance and guidelines, statutory guidance that we set. And thus, FISA, for example, was passed to set the standard for now conducting electronic surveillance in the United States for foreign intelligence purposes. So 50 years later, I think for the most part, First of all, what you set up is the intelligence collection programs that signals intelligence collection are the most rigorously regulated and overseen programs. If Jennifer knows, in the Department of Justice, if you're in the National Security Division, those are monitored by lawyers both internally, but that's because that was part of the deal. We're going to give you tons and tons of lawyers, both at the intelligence community level and at the Justice Department level. We're going to create a new court called the Fire Intelligence and Surveillance Court, and all of that is going to be how you do your work. And I was there sort of at the beginning. That was my tenure at NSA when that came into play. And I have no reason to believe that the basic tenets of the grand bargain have been shattered or ruined in any way. Having said that,
Quick, 20 seconds.
All right, General Hawk was relieved because he wouldn't do certain things, apparently. A military officer always commands as the director of NSA. That gives me certain confidence. If somehow, some way, Trump, for example, would decide to make Kash Patel a general and put him in charge of NSA, then I could make you no promises about the grand bargain or what would happen going forward. But for where I am now, knowing the people that work in that business, many of them, I am confident that at least at the functional level and in the military service level, those guardrails will hold even against this guy.
So I can see that we're going to have to reconvene here in a year, see how we're doing. Maybe 6 months if we really run into some dire emergencies. And please join me in thanking our wonderful fourth panel on intelligence exploitation.